Yes, Lordship. I am supposed to file the affidavit on behalf of the respondent numbers 1, 2, and 3. Can it be after 3 weeks, Your Lordship?
29 is the request for counsel for the provident fund.
Yes, Your Lordship.
It's submitted for counsel.
Yes, Your Lordship.
The file in the period 3 weeks as brief.
Yes, much obliged, Your Lordship.
May I please, Your Lordship? Lordship, with the consent of the attached, I beg to mention for item number 49 of the daily list, Lordship. In this matter, we need some time to file our affidavit in reply, Lordship.
49.
Lord.
49. Yes. 49 is the request of that. Week. Anything you provide?
Yes, Lord.
May I please, Lord?
Keep it applied.
My Lord, in item number 4, my Lord. My Lord, in the translated case, my Lord, there is a typographical error, my Lord. May I allow to, my Lord, correct it?
Typographical error.
Yes, my Lord. Only one word, my Lord.
One.
Only one word.
Let the matter be called up. You remind.
My Lord.
May I please, Your Lordship? Lord, in item number 12, Your Lordship, in today's daily list, Your Lordship.
Yes.
Yesterday, we have filed one additional affidavit Your Lordship, in connection with this case, Your Lordship.
Respondent petition.
Yes, ma'am, we are for petitioner. That is not tagged in this case, Your Lordship. So, my Lord.
Bring it. Bring it. You want it today?
Yes,
or you
yes,
want it on
Lordship.
some other day?
Yes, no. Today itself, Your Lordship.
Bring it. Give your-
Be privileged.
May I please, Your Lordship? Lordship, item number 39, 40, 41. The respondents were supposed to complete the instruction. It's regarding the non-consideration of appeal before the GST authority.
My Lord, I am praying for 2 weeks time to file our affidavit, my Lord, and to obtain our instructions.
Let us
Item 39, 41. Request is made by the company. They are filed in the sector. Here, we think-
Lordship, a date may be fixed, Lordship, because it's just regarding the consideration of appeal only.
Okay.
Deeply obliged.
Your blessing.
Also, I beg to mention listing one WBC Lordship.
Item,
Writ petition listing Lordship,
please.
admission matter. It was last posted on 17th of 2024. As per court's order, after 1 week.
Well,
Next week, any day.
next week. Any day. We list it on next Wednesday.
Okay.
24th.
Okay.
Well, please, Your Lordship, I beg to mention one item for listing, Lordship. The reason is the petitioners want to withdraw the case, Lordship.
Withdraw.
Yes.
Have it Monday.
On Monday. Obliged.
Withdraw. Yes.
May I please, Lordship? Lordship, I beg to mention item number 19, Lordship. The conducting counsel, Mr. A.R. Bhuya, is unwell, Lordship. So let the matter be adjourned for the day, Lordship.
Item 19.
Obliged, Lordship.
May I please, Your Lordship? With the consent of the other side, I'd like to mention item number 43. Lordship, in this matter, we will file affidavit in reply. 2 weeks time may be granted.
Item 43 is with
Obliged.
May I please, Your Lordship? Lordship, with regard to item number 18, Your Lordship, respondent number 4 has expired, Your Lordship, and respondent number 5 has, we got a new address of it. So, Your Lordship may grant us 1 week time to substitute legal here, Your Lordship.
Your name?
P. Deimari, Your Lordship.
Respondent number
4 has expired.
4 is expired.
And we got the new address of respondent number 5, Your Lordship.
Report legally and raise the 3 weeks time. Fair made allowed. It's happened. Yeah.
Much obliged.
Please, Your Lordship, I beg to mention listing of an IA for some typographical errors passed by this honorable court in the arbitration petition. My Lord, if possible, Tuesday. Much obliged.
Please, Your Lordship. I beg to mention item number 3. The counsel appearing this case, Lordship, is out of station, Lordship. Matter may adjourn for the day, Lordship.
This is up for the first time.
No, Lordship.
Item 3 at the request of proxy count. There the proxy count. Okay,
Deeply obliged.
Maybe later. I beg to mention item number 42, Lordship, for concern of the other side. Lordship. My senior is under treatment Lordship, in Bangalore.
Who?
I am the first petitioner, Lordship. Item number 42.
Who is under treatment?
I Talukdar.
Council for the petitioner is submitted council for the
This after 2 weeks.
report. Have you informed the other side?
Yes, Lordship.
Submitted that council of the council. Your name,
B. Hussain, Lord.
your name,
B. Hussain.
you say.
Obliged.
Yes, yes, yes.
Your Lordship, I beg to mention writ petition 1562. It may be short on 24/7.
Why?
The state has taken the land acquisition, and they are on full speed to go the road.
List on 24.
Thank you. May I please, Lordship, I pray for listing two matter for withdrawal.
Withdrawal. Monday.
Deeply obliged.
Thank you, Lordship. Lordship, I have checked the record. Impediment petition has not been tagged. So may I pay in item 15, Lordship? In this method, let the impediment petition be tagged and be listed to it on
15. You have
15
filed some
days.
implement petition.
already filed, Lordship.
When?
Filed before 2 days, Lordship.
You have the number.
I don't have right now, Lordship. I can consult my clerk. Let it be listed again on 22nd, Lordship, Monday, along with the,
We call for it if required. Call for it.
yes, Lordship.
May I please, Lordship? Matter has been enforced.
Yeah. What?
I want
Any other?
Okay. 3, 4, 5.
Entity appears for the 5.
4 and 3, 4, 5.
In the order to get it.
Deeply.
With the age or what? You had received some records. With recorded last time.
Right, Lord, I have gone for the record. My Lord, that amount not been, my Lord, paid to the, my Lord, that land, or my Lord, that partner,
Not paid.
not paid, my Lord, because, my Lord, there is some discrepancy in the, my Lord, the acquired land. Some of the portion, my Lord, which was acquired, that land has been, my Lord, in possession of the partners. And most of them, my Lord, that they have PWD already been returned to the higher authority for, my Lord, sanction, accord the, my Lord, sanctioning amount. My Lord, it was not deposited, Lord. Here the record is, my Lord, is up to 95. After that, my Lord, what whether they have received the, my Lord, the amount or not, my Lord, that is not clear in the, my Lord, record.
Then you file an affidavit.
Better to file an affidavit, Lord.
It's issued no.
No, no, Lord.
Third time. The other governor, it's a report. Here, the compensation if the
Only my lord, 50,000 has been my lord, deposited for the 50,000. Some of the portion of the my lord, that amount has been my lord, paid to the patarders for removing the my lord, that house. And my lord, said,
except for some amount. Entire amount. Yes, for them. He therefore if I expect paid to her completely I get let the bank be it's it after the date maybe get I get and then the other
I'm for 3 and 4 lord.
they public work
PWD.
uh, just for public work that is important that is important that is by one. Let them fight the rapid.
Lordship, any date may be given.
No, let it be after 3 weeks. Make it
Any date after 3 weeks, Lordship.
Let me call
21st. Okay.
August.
21st. Okay.
My lord, as per the last order, my lord, we have taken instruction that the bar association concerned is registered, but we are unable to, my lord, obtain the, my lord, that registration certificate. Now, accordingly, my lord, we have to, my lord, file an original with that figure.
You have to file.
Additional affidavit.
let the notice be issued, lordship.
So how can we why? Who is Liberty?
But the bar association of Busai,
Associate,
Bar
not the council.
not the council,
Your demand is the associate.
association.
You withdraw and file. When you obtain this copy, you file it.
Now, since it is not punishing, my lord, despite the, my lord,
You have to
repeated,
obtain, you have to go to concerned office and obtain a certificate. Registrar of cooperative, registrar of society.
yes,
You have to apply that.
that's true, my lord, but let notice be issued. In the meantime, my lord, I
No,
will,
notice it for what purpose?
the bar association,
It's not a registered body as on date.
it is a registered body.
That is your statement.
Yes,
There's nothing on record. So
if notice is, my lord, gone, my lord, they will respond it.
oh,
And in the meantime, I will collect the, my lord, registration.
you want the bar council to furnish the certificate.
Now, if they do not, my lord, deny the situation, as we have averred,
Right.
One and two.
Three, 4, and 5. Has been ordered earlier by her dated 24/7. Skip.
obviously,
To be agent did not be
additional
May it please the lordship. My lord, the related order is page 40, my lord. Page 39, my lord. Cooperative part at page 40, my lord. Therefore, without commenting on the merits of the claims and counterclaims of the parties in the petition, I dispose of the petition with the direction upon the respondent to expedite the process of preparation of the test map, Pandeg map, and also carry out the survey and verification of land involved in the present proceedings as noted. This direction was issued on 18/8/2022, giving a time limit of 1 year.
Direct. Oh, 88. Eight zero double three of 2019. By 1 week.
Well, the only thing my land trade has mentioned in the morning, my lord. You know, one word is required to be corrected. It has, my lord, your lordship kindly see at page 41, my lord. It has been translated wrongly that the hearing has been conducted. It ought to have been a hearing is fixed on so and so. Your lordship kindly see that date of notice is 4/2 and hearing was fixed on 13/2. So in translation, my junior friend, his junior while translating it, my lord, it has to be written as hearing has been fixed on 13/2. So we may be allowed to do it.
Where is the original?
My lord,
Where is the original copy?
original at my lord at see, kindly see, page 43. Particular.
When you correct it,
Yes,
presence of the court.
oblige. Oblige.
The lordship instruction has been sought for. My lord, the limited period about disposal of my petition for petition.
Lordship, I have received one Paravas. In the that Paravas comment, it is stated that the land has been meted in the name of some other person. Lordship, Lordship, may kindly go to the page 30, Lordship, of the petition, annex 5.
30.
30. Second paragraph. The last mandal, after examination documents, informed that the patta of the khas Miadi patta land covered Dagnava so and so. The Guwahati city second part has been recorded in the name of so and so.
That is my name, petitioner's name.
Well, here is the petitioner is Malal Krishna Chandra Das.
Same person, my lord. Let them take a call, my lord. Whatever.
No, that. You're referring to page 30.
30, lord.
They are not documented after that.
My lord, we obtained this land, my lord, the basis of the, my lord, litigation plan.
So prayer,
Prayer, my lord, limited to, my lord, dispose of my mutation application, my lord. Whatever they would like to take call, my lord, I don't have any objection. Page 10,
where is your application?
my lord, my applications, my lord, pending,
You have not closed here.
my lord, my page 32, my lord. 23. Since 2023, my lord, this, my lord, petitioner,
So let them pass the
my
order. Or no order has been passed yet.
no, lord, no. Nothing has been passed.
Why no order has been passed?
But in the Malade Parabate, the thing has been disclosed regarding that.
Been pending for more than a year.
This is very big problem. My lord. People are facing mutation application pending. They are running from pillar to post and vested
Actually, one of the problem is that
my lord,
earlier,
influence the
is-
system, my lord, and my lord, they are not allowing to go ahead, my lord. These are the problem we are facing.
that nowadays, Malade, the online application has been there. That my lord,
Online is supposed to expedite.
and my lord, due to pendency of my lord, that so many cases, my lord, that has been given so long, lord. That's why my lord, problem.
You get instruction the second half. Find out when this can be done. We are not passing an order just like that week, 3 weeks. Then again the matter will come back for contempt. Find out, get an instruction why these matters are pending. They have to proceed with the matter. Whatever orders they want to pass, let them pass.
Lordship, can it be taken on Monday, Lordship?
The matter will be taken. Take the government. I, yeah. Yep, pending. Yes.
Well.
The money again. Yeah.
My lord, yeah, my lord, page 65, the direction was given by the honorable earlier proceeding that
My lord, I need some time, my lord.
demarcation may be completed. My lord, whatever, my lord, demarcation was done only in respect of the DUG number 205, 202 not done. And they are continuing construction, we don't know whether it falls in 205, and under these circumstances, we filed these cases. And page 82, on deputy commissioner has instruction that to stop the any work in 205 only. 202 they have not done. But page 70, demarcation of both 202 and 205 to come to a logical end. And secondly, in page 70, there is also direction to record correction. That was also not done. So we are helpless now. So if any other course
How
of
much time do you require?
Lordship, 10 days, Lordship.
notice may issued, my lord, by that time in before vacation also, lordship is supposed to issue notice on instruction.
We were thinking of disposing it off.
Yes.
It did not happen. If we issue notice, it will be beyond 10 days.
What
Return
happened?
will be beyond 10 days. But get posted after 10 days, giving them an opportunity to place the instruction.
So our only grievance is that demarcation is not carried out in proper manner, and our record correction, that part was not complied with, page 71. Because we have the possession of the land recorded, but the record was deleted. So we approach. Now there is a direction to
In the record,
One.
Or 2 and 3.
step process for 567. I registered it within 1 week. Registered and served with extra period of 1 week.
interim prayer was there, man.
What interim?
On page
Notice
80,
on the interim.
page 82,
Notice on the interim recordable on 21st. Okay.
May I please, your lordship? The petition pertaining to obtain lordship passport lordship. Lordship petitioner has been provided.
Yeah.
I received instruction, Your
What
Lordship.
does it say?
Police report has not yet been received, Your Lordship. After receiving clear police report, then only passport will be issued. Your Lordship. This is the instruction, Your Lordship.
Police report is to be given by which police station?
Pagjuti, my lord, the petitioner has been granted the bail lordship. And I have annexed the bail order lordship. Case 21 lordship, annexed. Four 98 a lordship. FIR was lodged under section 498 a lordship. And petition has been granted bail. Lordship. The petitioner has been provided an opportunity lordship for a short-term visit to the foreign country lordship. Only 5 or 6 days lordship visit lordship.
They have sent it again for police verification
Lordship, yes.
on 28/6.
Yes, lordship. Lordship. I have annexed that order lordship. Page 24 annexure 5. Please verify.
What is your prayer here?
Lordship, a direction may be given to the
Whom?
lordship. Respondent number 2 is the lordship passport regional passport officer lordship.
So they have already done their job. They are awaiting for a police report. They have sent it again. After you appeared and placed the copy of the order stating that the criminal case has been closed, they have reinitiated requesting for police. It was sent on 28/6.
Lordship.
They are awaiting for the police. So direction, the regional passport officer is sitting there that is
Since my lord, it is a clear to lordship, then
it is a
since it is clear to lordship,
sorry, it is a
since the lordship police station given the instruction regarding who is the lordship, I am not clear.
if you share your instructions and They have already sent it back.
Yes, Lord.
So we close it now.
Yes, Lord.
If you hand over the copy, we'll give it to you. Take that. So, it's report. Regarding drug food case number 10. ID card. Yeah. Reinitiate. Taking verification. Same report and stated here here from the third path. Here the couple you with the observation that it is important to issue break of provision without further delay upon receipt of clear recording extends
Obliged.
Obliged.
Lordship, instruction was served to my.
Lord, I have received the pair of comments. Lordship, I am going to file an affidavit.
further evict
Lordship,
a Henry government hearing
1 to 4. Lord.
see instruction and reply by the Henry appeal if step number 4 by 9 by legal Indian after the return
Obliged.
Madam, maybe pass over 10 minutes. My senior teacher is legal for number 1.
good for the petitioner.
I am for the petitioner, my lord.
For the caveat.
Here the caveat
Yes, there is a caveat. There is a caveat.
pass it on, take it up.
My
Take it up at the matter.
Wait, please, your lordship. My senior is on legs. He's on under the court. Kindly pass over the matter for the time being.
May it please the Lord. Okay. In this matter, my lord, the petitioners are, my lord, pilgrims for Hajj, my lord. During Hajj, my lord, the committee, Hajj committee, asked them to deposit 3,82,279 for expenditure, out of which 1,54,694 was for chartered flight from here, from Guwahati to Jeddah, my lord. But
Some orders have been passed.
yes, my lord, this page number, my lord, 259. Similar, exactly similar circumstances, my lord.
Anyone for the respondent? Anyone appear?
Well, we have submitted a representation. We have limited prayer to consider our representation in a particular.
Who appears for respondent 3? Executive officer, Assam State also. The government advocate.
Government.
Similar matter আসলে নয়।
Millimeter. Consider. Problem.
Definitely. So this matter arises out of a NIT issued by the Assam Grid Corporation. Hmm? And it is being financed by Asian Bank. So the NIT was an international one. However, the response is from two Indian companies. And Millard, the NIT terms indicated the eligibility criteria, which according to us, we fulfill. That was a similar work to be done within a period of 18 months and a certain amount within a financial year. So both conditions we fulfill according to us. And therefore, we submitted the tender. The respondent 3 also submitted its tender. Then it's a two-bid system, the technical bid and the price bid, as your lordship know. First, the technical bid. The technical bid was open. There is a novelty which has come. That is, for the first time I have seen in a tender. After the technical bids are open, there is a provision in the tender that the respondent will issue a letter of its intention to award the contract to X, whoever has been assessed after the price bid is open, technical bid, then price bid. And that format of that letter is a part of the tender document. And it requires that you must give the reasons for rejection to all the tenderers. That is the novelty I have seen. That is in consonance with the judgments of your lordships and the Supreme Court, Millard, that it has to be a transparent process and it should appear from that that it has been fairly done. So the whole idea, I'll show that thing. Now, Millard, there is a clear departure and the impugn order only says that so-and-so, the respondent 3, has crossed that technical bid bar and his price bid will be opened on the next day. They have given the date. And I was there remaining only 2 tenderers. We have rejected the tender of so-and-so. So it is reduced to a 1 bid affair so far the price is concerned. And we have said that there is a huge difference of price as far as the tenders are concerned, about 23 crores or something. Now, if your lordship just have a look at that that format below, where this is required to be given, Kindly turn to page 51 for a moment, Milo.
Yes.
44, Milo.
44.
Yes, Milo. 44.1. Prior to expiration of the period of tender validity and upon expiry of the standstill period specified in ITT 42.1, standstill period is a period of about 10 days, which it is there in one of the form and terms. If applicable, the employer shall transmit the notification of award using the form included in Section 9 contract form to the successful tenderer in writing that its tender has been accepted. At the same time, the employer shall also notify all other tenderers of the results of the tendering. This is something which normally we don't find in the tender clauses. Kindly turn to page 151 for a moment now. This is the format which has been prescribed and which is part of the tender document. This is to notify you of our intention to award the contract. You have number of days specified in so and so from the date of notification to request for a debriefing in relation to the evaluation of your tender and or submitted a tender related complaint in relation to the intention for award of contract in accordance with the procedures specified in ITT 41.1, which is at page 62. Now, the summary of the evaluation are as follows. Then the name of the tenderers, then the tender price and evaluated tender price. 2, this is most important. Reasons why your tender was unsuccessful.
The new trend. This is something new.
New, if your lordship says that, I am happy because I have never seen it in a tender clause in this format, Willard.
That's good.
That is very good, Willard, in fact. And if your lordship sees now that particular thing, which your lordship at the bottom, Willard, reasons why your tender was unsuccessful. So it requires two things, Willard, not only the person who has been chosen by them to award the contract, but the other tenderers who have been rejected and the reasons for their rejection. That has to be given.
Now, this is technical or financial?
Both, Willard. This is after the technical and price bid, because it is an intention to notify the intention to give a contract to a particular tenderer. And that includes, Willard, the other half, namely the rejection of the other tenderers also will have to be notified by the same letter and the reasons for rejections to be specified. Your lordship remember those cases, even of 70s, where it was said that it must be a transparent process and reasons should be given as to why you have given to X or why you have not given to Y. But it was never a tender clause. Now this has been virtually a part of the tender process.
Yes.
Now kindly have a look at the impugn order which is there, page 252. They seem to be in the old regime, Milord. I'm concerned about the own tender clause. This is to notify that the technical tender evaluation of the submitted tender of the respective tenders is completed, the results of which are as below. I am number 1, Jackson, Milord. non-responsive. And B, this is the second tender, responsive. In this respect, it is also to notify that financial tender of non-responsive tender shall not be open. So they will not see my tender. Financial tender of the responsive tender shall be opened through e-tender portal on 10/7/24. This is the date is of 8/7. They say that we will open on 10/7. So authorized representative of the respective bidder whose financial tender shall be opened may present in the financial tender opening of the scheduled time and place. Therefore, the rejected tender can't even send a representative. D and F. Now kindly have a look at page 60. This is part of the tender document. ITG 42 plus 42(1) at page 60, Milord. This is the standstill period, 10 days. Milord, you give that letter and the standstill period commences and it is for 10 days. So that, Milord, the rejected person can have a opportunity to file a representation or a complaint. The employer shall, at the start of the standstill period, notify in writing each tenderer that submitted a tender of its intention to award a contract to the successful tenderer at the end of standstill period. The notification using the form included in section 9 shall include the following information. Name of each tenderer, we are not concerned. The D and F will be relevant, Milord. The name of the tenderers whose tenders were rejected and the reasons for their rejection. This is the most vital part. And then F, statement of the reasons the tender of the unsuccessful tenderer to whom the notification is addressed was unsuccessful unless the price information under E of paragraph already reveals the same. If you had opened my bid, you would have found that you are protecting the public interest by saving 23 crores, which you know that you don't want to do. That's the whole. Therefore, you specify that this will be done, and immediately on 8th, the impugn order is given. 10th, you say, we'll issue. So this is how, Milord, the matter proceeded. And immediately on 8/7 itself, we submitted our representation, which your lordship find at page 252, 253.
254.
253 is the email, 254 really, your lordship is right. So we are saying that we fulfill the eligibility criteria. We have done that in Maharashtra under Maharashtra Electricity Board during COVID time. In fact, the employer, that is the electricity board, Milord, invoke the force majeure clause in that case, so that, Milord, no penalty or any damage was caused because of the some period where, Milord, because of the bond, people could not come. But even then, Milord, the chart indicates that we have completed that project within 15 to 18 months. That is also there in one of their Maharashtra documents. Page 21. I think page 217. No, that is the accountancy. It's not 217. 207. Just have a look at that. This is from Maharashtra Corporation, 207. They indicate the COVID period and the force majeure clause, relief period, COVID 19 days in E, and net completion time taken 16.41 months, and the transmission lines 15 months. Therefore, the clause here indicates eligibility is 18 months. So in any event, Miller, this was an illustration.
So what is the reason for your rejection? That is not.
No, no, we don't know. So your lordship has seen that. And that's why we are immediately on the very day the order was issued, we placed
And
it.
this standstill period will expire tomorrow.
It should
No,
be done.
Notice of intention to allot the work has not been issued. That said, page 151, page 51 relates to opening of financial deal.
Correct, correct.
It's not the notice.
No,
that
no,
period
no.
has
This
not-
is after financial bit.
No, 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 no.
No, no.
You do-
See the thing.
No, no. You just.
No, no, you are right.
Yes,
I am not saying
this
anything
notice-
to the contrary. This is to notify you of our intention to award the contract.
Page 151.
Page 151. You have insert number of days, so much days from the date of notification to request for a debriefing in relation to evaluation of your tender and or submit a e-tender related complaint in relation to the intention of award of contract in accordance with the procedure specified so and so. Reason why then the list of tenders is required to be given. No, no, this is the format.
Format, no, what the letter?
No, no, let me show it. Reasons why your tender was unsuccessful. So your lordship has seen that clause that you have to notify all the tenderers and inform them as to why their tenders were rejected. Now, this is the format they have prescribed within the tender.
This form is in pursuance to 42.1.
Correct.
Yes.
42.1.
42.1.
42.1 also reflects that it is an intention to award.
Intention to award.
Award.
That's right. So intention to award can only happen after opening financial.
Financial, that letter.
That has already been opened and it is now in the
That
website also.
intention letter has not been issued to him.
No, no.
That is his ground.
No.
Because
If we issued the intention letter, my lord, then we have to give that other form, that form.
No, no, no.
Am I clear to your lordship?
The form indicates both.
Both. The notice. What is the notification?
What is the notice
of
given to
intention
him?
to
That
award?
your lordship can have a look at it.
Kindly
Subject is
see.
very much clear.
Page 151, notification of intention to award the contract. And the contents say that we have decided to award it to X. And the format requires that there may be other tenderers. You indicate the reasons why your tender was unsuccessful. That means this is required to be given to all the tenderers. And to the two bidders, one is being given, and the successful tender at page 152, you have to specify.
If your lordship kindly
So,
252,
how can
have a look
that
at it.
happen, Miller? If you don't,
252.
yes,
Notice of financial tender opening.
yes.
It's not lot. Has your lordship got it? 252. That stage is yet to come.
You have shown the impugn order.
That has been your relied notice, top of the notice. Notice of financial tender opening.
Miller, this notice is impugned. This says that your tender is non-responsive.
Yes,
You are not required to come to the financial opening, and
we will
open the financial bid only of one tender. And on 10th of July, and they have opened, and it is uploaded in the bill as to what the amount is. Therefore, we have come to learn about the amount, and we have filed an affidavit before your lordship yesterday, which is requisition now, and which shows, my lord, that it's an amount of how much? No, the difference is 3 crores, but 599 or something it is. We have said that in our affidavit now today.
If they have a grievance towards the rejection, if they are bound to be aggrieved by the rejection.
Yes,
So the question is, what are the reasons for rejection? You produce it.
yes.
Forget about uploading it in the website.
My
It will
lord,
be available
my
in
lord,
your-
my lord, can I submit one thing?
Even-
Petitioner is challenging that notice, which has been only notifying the opening of financial bid. Now the term stage of intention to allot the work not yet arrived at. Because after that, that financial bid has to be accepted by the board.
No, but your intention is clear now
Now,
that you have rejected him at the technical bid.
Yes, sir.
technical bid, because now
No, you don't have to come to the price
That
bid
will
and
be
two
given to
tenderers. What
the
does it imply?
responsive bidders. And from the facts, it appears that there are only two bidders.
two bids.
One is out, so the remaining one will have to be.
Maybe price in, if it is high price, then authority may not accept it. That I am,
That is
I have,
difficult.
cannot ascertain it right now. Because that stage has not come yet. Now, what I am on, my lord, while,
No, I'll just finish
Oh,
5 minutes.
let him,
We have filed this, before lordship, it has come now. The presentation is,
The affidavit.
yes.
Yes.
We have just given, because it has come in the website, we have come to learn about that price also. 1774, paragraph 3, my lord.
Yes.
That further in the memo of the writ petition, the petitioner has pleaded that the financial bid quoted by them was substantially lesser than the financial bid quoted by respondent number 3. The petitioner had quoted a price of 499.10 crores. The petitioner has reliably learned that respondent number 3 has quoted a price of 522 crores. Therefore, from the impugned order your lordship has seen, they have notified that my tender is not responsive, and the other candidate, which is the loan candidate, his tender will be open on 10th. And they have opened it, and this is the amount which they have found. And now, if they give that letter, which is impugned, and the columns clearly indicate that it has to go to the other tenderer, and the reasons should be there. Let them produce the record.
Produce the reason.
I will produce, I will point out one point, one thing, my lord. If your lordship kindly turn to page 70.
Page
70.
70.
Yes. 6970, that is the eligibility.
Yes, my lord. You start from page 69, my lord. Some documents were not annexed, are not annexed with the petition. Now your lordship kindly turn to page 70, clause 2. Has your lordship got it?
Page 70, clause 2.
Clause 2, Roman 2. Has you got it?
Yes.
The bidder shall either have the manufacturing capability of fabricated tower member at his own plant, or shall have a clear access from other reputed manufacturer plant of fabricated tower to be supported by legally enforceable document like MOU and affidavit regarding eligibility of fabricator having yearly manufacturing capacity of 9,000 metric ton. Such plant must have manufactured an average 6,000 metric ton during last 3 years. Now, in support of this document, two documents, one is authorization and one is credential of that authorized factory. Now they have not annexed those two documents along with
Very good. You give us the, we'll explain.
No,
You
no.
have not given us that.
No, I am coming. I'm coming to that. Why did these two documents, vital documents, were not annexed?
I don't
I'll supply him right now. Your lordship, kindly have a look at it.
No.
These are the two documents there.
We got anything about it?
দেখুন আপনার The first one is authorization letter. As your Lordship, I mark it.
Yes,
This is the authorization letter.
22 to 24.
Yes, my lord. They given it. And these authorization have no credential. Credential in next page, my lord. They annex it. They submitted along with the. This is a chartered accountant statement in respect of Keeper Limited.
These are on match.
No, my lord, I am coming. Why they are not annex this document along with the writ petition? Now, very interesting, my lord. Third page, your lordship, kindly look at the bottom. This certificate is issued at the request of the management of the company for onward submission by the company along with the other bidder document to Power Grid Corporation.
We have annexed that 221, 221.
Yes.
My lord,
No, we have annexed, we don't say.
No, no.
don't say. Who? These are on facts, my lord, we are not at the moment concerned.
no, my lord,
We are not-
authorization letter.
No.
Authorization by the good Lord. Authorization by the good Lord. And credential of keeper.
You give the reason, we'll explain. There is
No,
problem.
that's
Ah.
why,
Ah.
a major component was not
No,
submitted.
where have you said this, no? That is the whole problem.
You produce the
Record,
evaluation.
let it be in, I'll put their entire bunch of
Your tender evaluation committee.
committee next Monday or let it be on Wednesday, I'll publish it.
You can, I have no problem, but you should have included that in the format below that page. Rejection.
No, format on a plain reading, perhaps your submission, or rather the submission of the respondent, his submission appears to be what is reflected from the format. That this is to give you reasons why you were unsuccessful.
Correct, that is all I am saying.
Whether it is to be done at the stage of technical bit or financial bit is not clearly specified.
Because this can come only after technical bit is over, because they are saying that we have evaluated your tender, it is not responsive.
But their
That means the
interpretation,
technical bit we attended because it
prima
was-
facie, their interpretation that it can also be given after the award is given finally.
But that
does
does
not
not
appear to be
contrary to the
prima
clause.
facie does not
Intention to award the contract.
intention to award.
Intention to award the.
Act remains that you have already disclosed your intention now.
No, Milord, we have not. Intention means, Milord, when the.
You have not
No,
written
Milord,
it in
suppose,
writing, but your intention is clear now.
suppose financial bid was placed before the authority.
You produce it on when you want.
Wednesday, anything, Milord, next week I will
Mr.
produce
P.
it.
Goswami, learned senior counsel.
Let it be no motion stage, Milord.
Mr.
I have no problem.
K. Talukar, learned counsel. Petitioner, Mr. S. Konuki appears for AEGCL.
Hey, respondent number 2.
And who's for power? Who's for power department?
Government of Assam.
MSS Sharma appears for respondent number 1. Petitioner is aggrieved by the rejection of its bid submitted in response to the NIT issued by the respondent number 2 for construction of so and so page number 25. Work is page number 25. Description of the work.
Yes.
Page number?
25. Petitioner and the private respondent submitted their bids, and it is the grant of the petition that the bids submitted by the petitioner have been rejected and been found to be non-responsive and not with extending the very competitive price quoted by the regulator vis-a-vis the price quoted by the private respondent stock. Learned senior counsel has read the various clauses of the NIT/bid document. It's up that as per clause 44,
42.
42,
Two. 44, below, 44.2.
44 point. No, where is the disclosure of the rejection? Clause, page number 51.
51.
51, below.
51, this is 44, clause 44,
44.
as per clause 44.
And 42, my lord, intention of notification of intention to award the contract.
44.2,
42.1.
One.
42.1.
During
40, as per clauses 42.1.
44.1, my lord, that
There is a
format
it provided that
which you find
There is
at
a
page
notification.
151.
which will convey the intention to award the contract. So, as per clause 44, there is a standstill period of how many days? 10 days.
10 days.
10 days.
10 days from the date of
Intention to
intention to award the contract. Stop. The council for the referring to tender data sheet segment. Submit that as per clause 42.1. The employer at the start of the standstill period is to notify in writing each tenderer that has submitted a tender of its intention to award the contract to the successful tenderer at the end of the standstill period. So the notification will include the following: page number 60 ABCD. So the senior accountant refers to the where is the form?
form
151.
Refers to the form that goes to the bid document, which is required to be through which the employer is required to communicate the intention to award the contract. He submits that in the form at serial number 2, the reasons why the tender was unsuccessful required to be disclosed. So, Learned senior counsel submits that upon the financial bid being opened of the private respondent, it has been and put up on the web portal. It has come to the knowledge of the petition that the respondent number 3 has quoted a bid price of 522.0 crore as compared to the bid price of 499.10 crores. Is submitted, there's a huge potential loss which will be incurred by the employer on awarding the contract to the respondent number 3. He submits that this is the award of the contract to respondent number 3 involve loss of public without giving due consideration to the bids given by the writ petition. It is submitted that on 8/7/2024, the notice of financial tendering opening was intimated and the writ petitioner's bid was found to be non-responsive. Therefore, it was informed that the financial bid of the non-responsive tenderer will not be opened. Immediately thereupon, the petitioner has put an application representation before the competent authority by email as well as by in the physical mode. Stop. Representations that remain pending and no information or reasons were furnished to the writ petitioner showing the grounds as to why the tender was considered to be unsuccessful. Under such circumstances, he has approached his court with a prayer that the tender stipulation have been flouted in awarding the tender to the respondent number 3, and the reasons required to be communicated, which is a part of the bid document, has not been done so by the respondent. Therefore, adequate protection be granted to the writ petitioner during the pendency of the writ. Mr. S. Kotoki, Learned Counsel, appearing to respond to disputes the contention of the Learned Counsel, Senior Counsel, writ petitioner, submits that the interpretation given to clause 42 and 44 is incorrect. The intention to award a tender by the employer will be notified only upon lifting of the financial bid and a decision to award the tender is taken. Stop. That stage, as on date, has not yet arrived. The interpretation sought to be given by the respondent that at every stage the reasons are required to be intimated, namely, even pursuant to the rejection of the at the technical bid, is an interpretation which cannot be permitted in terms of the provisions and the various clauses of the tender bid. Stop. He further submits that certain vital documents, these were not produced or produced.
Where?
This document before
Yes, yes.
No, one document was produced, the other was the authorized
submits that
221 page.
the documents
credential was produced, but authorization has not been produced.
does not reflect does not uh, inspire confidence in the respondent employer to accept the bids of the writ petitioner. Therefore, the same was found non-responsive. Stop. Mr. Kotoki, however, submit that he will produce the relevant records containing the bid evaluation decision of the bid evaluation committee on.
On any day next week, Milo.
You give us a date.
No, Milo, I am ready any day.
24th.
Logic convenient.
24th.
What is it?
24th.
24th, Wednesday.
Wednesday.
25th of October. 25th.
On 25th. Stop. Mr. Kotoki submits that as on date the award of letter of intent. So what do you call it?
My notice of intention to award the contract has not been issued till today.
The notice of intention to award the contract has not been issued and the contract has not been awarded.
Not yet.
Not yet.
Contract has not been awarded.
No.
As on date.
The status quo should continue.
Accordingly, let the matter be listed on 25th of July 2024, on which day the respondent number 2 will produce the relevant records containing the decision of the bid evaluation committee rejecting the bid of the writ petitioner for perusal of the court if the bid were right. Stop. Since Mr. Kotoki has entered appearances on behalf of of respondent 2 and MSI Sharma on behalf of respondent 1, this is the way extra copies be furnished. However, respect to respondent 3, you have to take Dusty. I don't know whether you'll be able to take Dusty on respondent 3.
Dusty is email.
How can Dusty be by email?
In
addition to the.
The notice we served on respondent number 3 by Dusty routed through the registry of this court, and a copy of the writ petition is also permitted to be served through email to respondent number 3. Further orders to be passed on the next day.
Status quo will
on
take.
date.
No intention.
Status quo.
Huh?
Status quo is on
My
date.
lord, no, what is,
No, what is that?
sir, this is a
Status quo.
project, my lord, AI, bank
25th.
project, my lord.
We are having it on 25th.
Uh-huh.
My lord,
25th of July.
till 25th.
Ah,
of July.
yeah.
My lord.
Make us the infrastructure.
The extra copies be furnished.
Yes. Thank you. Deep level.
Yes. We'll issue notice at this stage. Project.
Yes, my lord.
Further in council for the 4 weeks. MSK Devi. R Devi appears for all responded.
All right.
All responded. Since then, standing up.
My lord, if you can provide a short date, if you can provide a short date in the matter.
Respondent appears for all the council appears for all respondents. Notices of effect copies be furnished within a course of 1 week. Then you make it returnable 3 weeks. Then it will be tested again. 19 August. 19 August.
Much obliged.
My lord, fact of the case is that in the year 2022, the cyclone destroyed the houses, and thereafter the government of Assam announced the relief fund. And thereafter the circle officer along with Kaupura and Lakmandal visited the destroyed houses and take the GPS photographs and all the others cards and bank passbook of the beneficiaries, but the actual and genuine beneficiary is not getting the funds.
Under what provision you are asking for the funds?
My lord, the circle officer announces the relief fund, but
How can the circle officer announce? There must be some scheme.
yes,
What
yes,
is
my
the
lord.
scheme?
My lord, there is one-time benefit, government benefit.
Where is that?
My lord, notification is not there, but the list of beneficiaries is there. Annexer 1, my lord, page number 14.
Who has furnished this list?
My lord,
Where have you got a copy of this list?
my lord, from RTI report.
RTI.
I applied for RTI report and
So you
getting this
applied, but
reply.
this list does not contain any document, any other communication to show that this is a list for the of the beneficiaries for that scheme. It only contains a name. You are asking for 95,000.
Yes, my lord.
Some have been shown here as 3,000, 5,000.
My lord, some houses are not. Some houses are partly destroyed. Some houses are completely destroyed.
Yes, respondents, what is the scheme?
Has fallen from this honorable court. There's-
Firstly, when was the cyclone? Which year?
That is also does not find place in the petition.
Cyclone in Assam or somewhere else?
That, well, it's nebulous. The entire petition is nebulous. Whether at all,
Get the instructions. When was the cyclone?
that is also
Sir,
not
sir,
mentioned.
in Assam, my lord,
Huh.
the cyclone destroyed the houses in the village of Kundulimari
So
and
we
the
can
being revenue
understand the
circle, my lord.
storm destroying the houses.
Well,
Storm and cyclone here.
whether at all this honorable court would even
It is for you to tell us.
direct us to
No, we are not directing you. We are asking you to get your instructions on what the claims are.
To know, my lord, what is the scheme under which which he is claiming?
That your
And
department will
also
instruct you.
the parties, my lord, there are hundreds of people.
No. You get your instructions from disaster management
Disaster
and the
management
deputy
is here, my
commissioner.
lord.
As well as the deputy commissioner, circle officer. He says circle officer is giving some. Where is the communication of the circle officer?
My lord.
You said circle officer is
Yes, my lord.
distributing the scheme.
Latmondol and Gaubura visited the affected area and take the necessary photographs and bank pass.
You find out from disaster management if there is any scheme there to that effect.
The year 2022, my lord.
We don't know which year.
That he does not say.
No, he says cyclone in 2022.
In the year 2022.
Cyclone in 2022. 15/4/2022, paragraph 4.
Yes, well.
Then he wakes up, my lord, after 2 years.
Now 2024, my lord.
No. We are saying that is there a scheme?
Yes.
If there is a scheme,
My lord.
if they satisfy, they should be considered.
And
You first find out whether there is a scheme
my lord.
for giving benefits.
Notice may go, my
That is your problem. You always ask for notice. We are not inclined to issue a notice.
Notice.
You get your instructions
My
there.
lord.
Third, learned counsel for parties, learned counsel appearing for the disaster management. MS T.R. Monto, we obtained instruction as to whether there was any scheme initiated by the government of Assam or any department for grant of benefits in respect of persons affected due to a cyclone, which the petitioner claims destroyed their houses on 15/4/2022. If any such scheme is available, the learned counsel will apprise the court on such instruction we received from the department. MS.S. Sharma, learned advocate appearing for the
Respondent 3 to 6.
correspondent number
3 to 6, my lord.
326 will also apprise the court about the existence of such a scheme and distribution of any benefits under any such scheme,
Extra
to which the petitioner claims is entitled to. In order to facilitate the council's to obtain instructions, extra copies be furnished within 1 week from today. It will be listed after 3 weeks.
Like,
You give extra copies within
Sure,
1
well.
week.
Right, man.
This matter, does anything survive here?
Nothing. In fact, Mr. Kormakar is no longer there.
Right. That is what I wanted to confirm.
From that, my lord, judicial order not have been challenged in the writ petition because the challenge has been made to a judicial order.
Judicial order, there was some criminal revision which was also
That-
filed.
Yes, but if your lordships kindly see the prayer portion, page 15, set aside the impugn judgment and order dated so and so passed by the respondent number 3 in the case CR case number so and so.
No, that will require some examination, whether we
Yes.
can pass or not pass.
But the fact,
Like to
the
pass.
main fact is that, my lord, Mr. Kormakar is no longer.
It is submitted to the bar that the council petitioner in person has since expired. Has appeared up to the petition, that the writ petition should be pursued in substituted capacity. Accordingly, writ petition stands the request of this court, Mr. H. Das that appeared, H. K. Das appeared for the Guwahati High Court.
Respondent number 3, my lord.
Standing counsel Guwahati High Court.
Yes.
Yes. MS S. Sharma for 1, 2, and 3.
No. Yes. No, 2 and 3. Chief Judicial
2 and
Magistrate.
3. None appears for respondent number.
Highly.
Made to the lordship.
Yes.
This petitioners has been in possession of my lord filling surplus land in the Gopur grant number 654 and DAG number 275. There, my lord, if the stay of their forefathers are concerned, then it will be about 40 years, 50 years like that. Now, my lord, your lordship will find they have applied for under that Procedural Order 2.0 and also directly applied before the Deputy Commissioner for Settlement. Now, I could find, my lord, this land policy 2019, it has for the first time introduced 3.1, where, my lord, homestead in the village areas has been allotted, can be allotted under this provision.
What has been allotted?
For homestead. Earlier, these were settlements were made for agricultural purpose or some other purposes, but for the first time, this has been, and on the basis, my lord, 3.1 method.
Yes.
So, my lord, this particular provision has been examined by a division bench of this honorable court in PIL number 10 of 2018, so motto. And the relevant person, they have given, this honorable court has given certain guidelines what to do for getting the allotment application. Your lordship will kindly see at page 14.
40.
14, my lord.
1.
My lord, these are the your lordship will also find in the judgment. I have quoted from the judgment, my lord.
No, that's all right.
Yes, my lord. The Deputy Commissioner Kamrup M and the respective circle officers, if upon the materials on record are of the view that certain persons are illegally enforced upon government land, individual notice upon under Rule 18 of the Regulation 1866 be issued, and forthwith and all such individual notices be dealt by passing individual reasons order. That is very important, my lord. And may such and in any such notice, if any of the persons takes a stand of having bona fide claim over the land, the same to be decided upon by the Deputy Commissioner based on materials on record that may be produced by such person. Then, my lord, if in respect of such individual persons, the Deputy Commissioner arrives that there are no bona fide claim, the appropriate reasoned order may be passed. On the other hand, if the order is in respect of any such person is that the person may have a bona fide claim, the Deputy Commissioner may accordingly pass his own order and subject such person to appropriate provisions of law. Then, my lord, 2. If any of the persons making any individual applications for allotment of land under the land policy of 2019, the Deputy Commissioner shall subject such application its appropriate consideration under law and pass reasoned order whether the facts and circumstances of the individual, the person concerned, has any legal right for allotment of the government land, and accordingly, if the Deputy Commissioner is of the view that given person is not entitled, a reasoned order shall be passed. And on the other hand, if the Deputy Commissioner is of the view that somebody has any kind of entitlement against another, again, another reasoned order may be passed. So, my lord, here we have made the applications. And
no, who are you, the first place?
I am an indigenous person residing there, my lord, in the Gohpur grant number 64654 and dag number 175 for long, my lord. I have given the documents to show that I am in possession by giving the this my lord to the Bahira land revenue from my lord 1960 onwards, my lord. So that accrues certain right on me, my lord, and above all, my lord, this notification of eviction, my lord, that had been passed during the on my lord 12/7/2024.
Where is the note?
It is your one is at 64, my lord. The one is 61, my lord. Your lordship will find it. My lord, 65, and the Assamese version is 63. If your lordship allows, I may read the Assamese version also. Gohpur Chokra, Sabagiswar 654, Deoburia Bazar Gate, Kolongpur. Gohpur Moja, সভা সমিতিয়ে যোৱা ইংৰাজী 20/6/24 তাৰিখে পৌৰ সেন্সাছ নম্বৰ জৰিয়তে অসম মাননীয় মুখ্যমন্ত্ৰী মহোদয়লৈ দাখিল কৰা চিঠি আৰু জিলা আয়ুক্ত নিৰ্দেশ মৰ্মে সংশ্লিষ্ট ভূমিলেখ্য বিষয়া আৰু ভূমিলেখ্য পৰ্যবেক্ষকৰ দ্বাৰা কৰা সৰজমিন তদন্তৰ পৰা জনা গৈছে যে কলংপুৰ মৌজাৰ অন্তৰ্গত গহপুৰ চাহ বাগিচাৰ 54 নম্বৰ গ্ৰান্টৰ 275 ডাগৰ চিলিং চৰকাৰী বিনা হুকুমে আপোনালোকে অবৈধভাৱে দোকান ঘৰ সাজি বেদখল কৰি আছে। গতিকে আপোনাক ইয়াৰ দ্বাৰাই আদেশ দিয়া যায় যে এই জাননী পোৱা 15 দিনৰ ভিতৰত উক্ত জমিৰ দখল সম্পূৰ্ণ ৰূপে এৰি দিব, অন্যথা আইন অনুযায়ী আপোনাৰ লোকক বলপূৰ্বকভাৱে উক্ত মাটিৰ পৰা যিকোনো সময়তে উচ্ছেদ কৰা হ'ব আৰু জৰিমনা বিহা হ'ব। তদুপৰি উচ্ছেদৰ সময়ত জব্দ কৰা সামগ্ৰী নিলাম নষ্ট কৰা হ'ব। এই বিদেশৰ জাননী অসম চৰকাৰৰ ইমান তাৰিখৰ 2024 আজি 12/7/24 তাৰিখে সহি কৰি দিয়া হ'ল। My contents of the Lord TV. This is contrary to the provisions of land allotment policy 2019. We have applied for settlement, and they have given. Your lordship will find it 58, page 58. These are online application for settlement under Bosundhara 2.0. Acknowledgement has been given for both all the persons. One is at 58, madam. Your application for settlement of khas and ceiling surplus land has been submitted successfully on 23/3/30 and your acknowledgement number so and so. Please use this acknowledgement number for tracking the application and for any future communication related to this application. If the application has been accepted by the Revenue and Disaster Management Department, service shall be provided within 300 days. You may raise an appeal so and so. If the service is not delivered within 300 days, you may call upon so and so. Paid rupees 320. So my submission before your lordship is there. We have applied by this and also individually through the deputy commissioner directly. But these two are pending before the competent authority. In the meantime, my lord, contrary to the provisions of this land policy 3.1, the circle officer has placed this, my lord, eviction notice served us on 12/7 and wanted to evict us. At this stage, my lord, why they have not, what the result of our application is not known to us. They have not, we have inquired there, they have not said anything on that. So,
Where are your application? Page number 39, 59.
any our application. If one is 59, correct, your lord. With due respect, the undersigned being beg to state that we have been occupying permanently the land measuring 1 katha 10 lessa, very small portion of land, my lord. They have divided between their family members only for the last 50 years by constructing residential house, which my family without any interference from any quarter. I have paying government revenue, land revenue up to 2020, but after 2020, land revenue is
Yes,
not.
Mr. Borgoy, we find out what is there. Yes. What has happened to the representations? Have you been disposed of? What?
To that extent, my lord, we will have to take
You get your instructions on that.
No, but there is one another aspect of the matter. Lordship will kindly see, my lord, they are in occupation of tilling surplus land. Now, for that reason, my lord, there is a specific statute, Assam Fixation of Tilling Act 1956. My lord, neither the provisions of the land policy, my lord, are affected so far as, my lord, eviction of those persons are concerned.
No, no. Sealing surplus land is they have not been allotted with this land.
Yes.
The sealing surplus land will be applicable to the garden or whoever was occupying that land.
No,
but so far as these people are concerned, they have no land. They were just occupying that particular plot of land which happens to be sealing.
Now, yes, that is true. But here, my lord, Lordship will kindly see, my lord, a reference has been made, my lord, to page number 14.
There is a judgment, division bench judgment, which
Yes,
is laid
division
down.
bench judgment. Now, my lord, after this notice, my lord, Lordship has seen it, my lord, at page number 63. I am just drawing your Lordship attention, my lord, to the vernacular portion at page number 63. Now, this notice has given, my lord, a period of 15 days for them, my lord, to evacuate, or they will be forcefully evicted, my lord. This is the tenor of the notice. Now, after this notice, my lord, even if we go by the dictum of this honorable court pronouncing the PIL, they could have filed an application before the deputy commissioner that look, that we are aggrieved by this notice. This is our bona fide claim. Nothing as sort, my lord, has been required before the deputy commissioner.
See, they are not. You have to understand the the accessibility to legal advice. So these people, whatever, who is going to advise them what letter is to be filed, how it is to be filed, who is going to draft it for them?
Now,
they have already filed some application.
They have filed an application, but my lord, under the provisions of the Sealing Act, my lord, only the landless cultivators who are residing nearby.
You pass your orders on that. If these applications are pending, pass your orders on that. Whatever orders you need to pass. They are people, they are residing somewhere. If you throw them out, see, there are different kinds of eviction. One is, let us say, there is a plot of land for construction of some industry or something like that. These are unauthorized occupants suddenly appearing from somewhere, or maybe have been there on a part of the land. This is one aspect. The other is people like them who are living for decades, and you identify, yes, these are selling surplus land, so they will be there. Where will they go? You have to, under the land policy now, you have to consider their cases. You consider them. They've already filed their application. If you need fresh applications, then file.
Now, yes, now, my lord, coming to the mood issue, if lordship is protecting them in the interim, lordship will be issuing only a short date, my lord.
Yes, yes.
Yes. Because I will have to seek the instructions, my
get
lord,
your instructions,
and
yes.
we will file an affidavit, my lord. Lordship will
You want
only
us to
seek
issue
the matter,
notice? You want us to issue notice, or you'll get your instructions
instruction and file affidavit.
without notice?
We will produce the instructions. Then, my lord, lordship will be issuing a short notice, my lord. Yeah, they will be protected
Alright,
till the next returnable date. only.
AC Puraguhai, Learned Senior Counsel, assisted by MS.
No,
It's not. Not.
no, any.
Mr. Harbor Pudari, abuse for
Respondent number 1.
respondent 1. MSS Sharma, abuse
Two and three, ma'am.
with 3. Petitioner claims the evidence of residence of photo plan under the Gopur Estate Grant number 654 and a part of that number 275, measuring 1.5 quotas of land under the same act number. They have been residing in the same areas for about 80 years since their forefathers and ancestors. They have been paying the Dozi Bahira land revenue since 1965. So the petitioners had filed a representation before the deputy commissioner earlier. 59, deputy commissioner's representation,
Yes, my lord.
page 59.
59 and the 20 Bosundhara 20 applications are, my lord,
Let's see.
are there.
Deputy commissioner to settle the land under occupation. Representation was filed as per
And
then
55.
50,
55 is the under Bosundhara 20. 55.
so the that part, they
55,
also filed
58.
application under Bosundhara 20 scheme by making online applications. So, the applications were made for settlement of costs and selling surplus land. So, although the representation and the applications were received by the respondent authorities, no orders have been passed making allotment to the writ petitioner or in the alternative rejecting their application. So, however, being that situation, the petitioners were served with eviction notices and in circle officer. The rule 18, the petitioners that they will be evicted. Their they has been the city, their city surplus. So, senior council has submitted to judgment. Court. And 30
Judgment to near. What is that?
EIL within brackets slow motor 10 of 2018 passed by this court. ID judgment order agency. The Learned Senior Counsel refers to the same judgment and submits that detailed procedure. This court had directed detailed steps to be undertaken by the revenue authorities in matters pertaining to eviction of people where it needs to arise. So that is city council that is steps have not been followed. The direction of the court, EI number 22 has been completely flouted. So the representation and the application filed by the petitioners have not been considered and same are lying under being thus situated. They have approached this court and it the new eviction notices and consequently pray for protection. There are for Pujari Planning Council that the eviction notices are in respect of selling surplus land. And the
There is a definite statute, my lord, the Assam
they-
fixation of
these are
ceiling Act.
under the provisions of the
Assam fixation of ceiling Act, 1956.
Fixation of Ceiling Act 1956. And the petitioners are within their rights to approach the deputy commissioner filing necessary representation against the same. However, same has not been done. So he however fairly submits that as on date he does not have any instructions with regard to the application and representation filed for allotment of land and allotment and settlement of land with respect to the petition. He therefore submits that since the steps have been taken by the circle officer under the specific statute, there's no infirmity in issuing the notices and the authorities be permitted to carry out their statutory duties. Having heard and counsel parties, let notice be issued, returnable.
My lord, let it be on 29th of this month, my lord. I'm sitting only 10 days time, my lord. 29th, my lord, kindly.
29.
29, my lord. We will inevitably file our affidavit.
Considering the issue pertains to the eviction of the petitioner, which is strongly contested by the respondent, let notice be returnable on 29th of August, of July.
July. 10 days time, my lord.
Are you sure?
We will file an affidavit, my lord.
Right, 29th of July. Enabling the respondents to complete their instructions and file necessary affidavit if so advised. This court has fixed the returnable date on 29th for submissions made by the respondent counsel that they would be able to complete their instructions. According to matter be directed to be listed, matter is directed to be listed on 29th of July till 29th. The impugned notices shall remain same. Extra copies be furnished
by today itself.
By within tomorrow is a Saturday.
Tomorrow Saturday, my lord, we will lose.
All right.
2 days, my lord. We will lose 2 days.
Will extra copies be furnished within the course of the day to the respondent counsel. Yeah.
I'm so obliged.
Your lordship is said up to 24th.
29.
29.
29.
Obliged.
Yes.
May I plead your lordship? The implement petition may be allowed.
Hmm?
The implement petition may be allowed.
Where is the implement petition I get? Huh? You have not filed any.
Yes, my lord. Filing date on 19/6/2024.
We asked you to give a requisition for calling the implement petition. Why have you not done it?
My lord, matter may be fixed on Monday.
No. Then it will be listed after 2 weeks, along with the implement petition and report by the council for the petition. Yes.
Item 16. May I plead your lordship?
Lordship, the petitioner was called to give a hearing, and thereafter an order was also passed. So the petitioner was disposed of the direction to take a decision on the petitioner's representation.
Where is that order?
Where
is the order?
It's at page, it starts at page 24. And the relevant part is at para 8, page 29.
Page 24.
It starts.
It start page 24, my lord.
Then
Relevant para is at page, paragraph 8, page 29.
you are representing whom?
I'm representing the PF. Put the respondent.
So now the hearing was done.
Yes.
Okay. Yes. The hearing is done, Mr. Ghosh.
I have received it today, man. Let you open a instruction, man. Let him pick some other day.
All right.
Just I have received it.
Mr.
Right
D.G.
now.
Ghosh appears for the contempt petitioner, for the petitioner.
Yes.
Mr. R. Sharma
Yes.
appears for the respondent number 2.
Who's the respondent?
For both the respondents. He submits that in terms of the directions of this court, by the order dated 1/2/2023 passed in WPC number 396 of 2023 has been undertaken by the respondent authority. Copy of the order dated 18/7/2024, which is addressed to the writ petitioner by the respondent, is placed before the court. Copy of the same is retained in the case report. Learned counsel for the petitioner submits that he would like to complete his instruction and therefore the matter be listed after 2 weeks. Is accordingly up.
Item 17.
May it please your lordship. In this case, lordship, I am for the petitioner. And as per order dated, lordship, the last order is 26/6, lordship. Matter is fixed on 7/8, lordship. But today it has been listed as by order. I have not made any mention.
Okay. Have you made a mention?
Yes, I have mentioned.
They made.
Because my lord, they have got the interim order fraudulently. And by tech deed, I will tell your lordship, at least we have filed.
You are appearing for whom? The respondent.
I am for person number 7, man.
7.
Yeah.
You file your application.
No, I have a packet petition I have filed, that is here.
That is pending, lordship.
That is filed, that is also served.
Lordship, kindly see order dated 26/6, lordship. There is a clear direction to file the affidavit to the BTC, lordship. And BTC has filed today.
Filed there. And BTC.
I will file reply, lordship, to them.
My lord, BTC affidavit, there is nothing, they are clearly supporting our case. Because my lord, fraudulent deed, my lord, I am submitting, this is our land. Then my lord, fraudulently, they
procured a false document and filed a petition that our name should be included with the Namjari.
Yes.
That was done. We came to know about this, then we filed a petition before the Circle Officer Bogrivari that they have included their names along with us. Two brothers' names were there. They are not their relatives, not anything. They included their name along with the name of respondent number 7 and 8. Then, my lord, we filed petition. Then ASO Bogrivari issued notice to the present writ petition that a complaint has come that you have fraudulently obtained the mutation order. Then, they, after receiving the notice, and the ASO sent a letter to the registrar whether this deed is genuine or not. Then registrar said this is faulty. Then you are afraid of police action, and then this without when the matter was sub judice before the ASO on the waiting that he will examine the matter, hear the party. Immediately by filing a false petition again, they filed a petition.
You are filing the IA for vacating.
Vacating. Then
we'll take up both the matters. On when do you want it? Tuesday, Thursday?
Lordship, before that, I will file my reply to
You
the
file it by
affidavit.
Thursday. We'll take it up.
Next Thursday, Lordship. Yes, Lordship.
25th.
Yes.
25th or 30.
Lordship, by next week, I will file my reply, and after that, your Lordship may pick the date. The week started from 29th, Lordship.
On 29th.
30.
31, Lordship, it's a Wednesday.
This is the vacating petition will require some here.
Yes. Then your Lordship on Tuesday, Lordship. It's a
30.
30th July.
The learned standing counsel PTC submits that the affidavit has been filed. The learned counsel for the petitioner submits that she would like to file a rejoinder. Mr. M.U. Mahmood, learned counsel appearing for respondent number 7. Submit that the interim order obtained by the writ petitioner was obtained without placing proper facts before this court, and therefore he has filed an IA, being IA number 164 of 2024, seeking vacating modification or of the interim order passed by WPC number 6069 of 2023. Under such circumstances, this court is of the view that both the IA and the writ petition can be taken up for disposal together. Accordingly, let the matter be listed on 30 July for hearing and disposal.
And Lordship, there is already an order to list this matter on 7-8. That may be modified, Lordship. That may be modified. Already.
But may I pray that it will be taken as part of.
Where is the hearing? He is yet to file a response. Then have it on 7-8. It's already fixed there. Why unnecessarily?
Actually, my lord, the land is to be sold for my.
Only 7 days. Lordship. On 26 there is an order.
The
land has to be
matter has already been fixed on 7-8. Therefore, be listed on 7-8 for hearing and disposal.
I am deeply obliged.
Item 20.
Yes.
A service report upon the restaurant numbers 7 is awaited, madam.
You have not taken steps?
Yeah, I have taken, madam. Already.
17-7.
I have taken.
When?
77, just yesterday I have taken.
Yesterday you.
Yes, I have gone.
The office note dated 17-7-2024 reflects that no steps have been taken by the writ petitioner on the response. Stop. Mr. P. Sinha, learned counsel for the petitioner submits that he has taken steps
yesterday.
That is 18-7-2024. Accordingly, let the office make necessary endorsement and the matter be listed after 3 weeks. For service report. 3 weeks for service report. For service report.
For article 21.
Yes.
Yeah, please, Lordship.
Lordship, on last occasion, the respondents had sought instructions from the Forest Department regarding the review petition pending before the respondent number 3 regarding the release of the vehicle.
Yes, who is for the forest department? Please notify forest. We take, come back at 2 p.m.
2 p.m. Okay.
Forest department at 2 p.m.
My lord, on the last occasion, the lordship directed us about his original records.
There's some caveat, isn't it? Yes,
No, that part is over, my lord.
is it?
No, that is not motion, my lord. That will take up, my lord. No, this is admission, my lord.
All right, yes.
But we are yet to receive the record. I take for some time.
Yes, Mr.
My lord.
My lord, I am appearing for respondent number 4.
Yes.
After receiving the record clarification from the revenue authority, if required, will file the affidavit.
Who are you?
Respondent 4.
Who is the respondent for?
After clarification from the revenue department, record was supposed to receive.
Mr. T.K. Monto, senior counsel, assisted by Mr. T. Gogoi, appears for the petitioner. Mr. T.K. Talukar, that is senior counsel, assisted by Mr. Eddy. Appears for the respondent number, for the state respondent. Subsequent instructions are awaited. Praise for further time to complete his instruction. He prays for 3 weeks further time. So, Mr. Your name?
S.A. Bakhtiar for respondent 4.
S.A. Bakhtiar appears for respondent number 4.
4.
And MSPR Monto for
1, my lord.
respondent.
Our name is not shown in the cost.
To be listed after 3 weeks. Names of all council be reflected.
My lord.
by the next
Interim
week.
order pass highly shall continue.
Sorry,
Interim order pass highly.
interim order pass early will
Leave it. Ready.
Item 23 and 24. I'm sorry, Lordship, in item 17, I have forgot to pray for continuation of the interim order, Lordship. Item 17. There been stay
Till
vacating.
7. Till
Lord.
7.
17
Order.
item, Lordship.
Item number
17, Lordship.
17.
Apply.
Let me take up the matter after some time, madam, or at 2.
Or at 2. All right.
Maybe on another date. Today I have just received the affidavit.
I filed additional affidavit in persons to be ordered at 16/2/2024. That is regarding deviation of a building construction. We have issued stop construction notice. That was challenged.
Yes,
Madam, pick up
some other date.
after a week.
Okay. Mr. M. Saiwala appears for the petitioner. Mr. Sharma.
M.K. Sharma.
M.K. Sharma appears for
Respondent number 4.
respondent number 4. Mr. H.K. Sharma appears for
Respondent number 2 and 3. Johan Municipal Board.
2 and 3. Submits that an affidavit has been filed.
Additional affidavit.
Today.
No, on 28th of March.
Then how come you receive it today?
My lord, today I have received, there is an instruction by this honorable court to supply me a copy, my lord, which I have received today. 16/2/2024, my lord, for the detail.
In pursuance to the affidavit filed on behalf of respondent, sorry, as counsel appearing on behalf of respondent has filed an affidavit in deference to the order
But it is
16/2/2024. Learned counsel for the respondent number 4 prays for further time to complete his instructions on the affidavit stated to have affidavit filed by the respondent.
Affidavit
Counsel
without the
submit-
annexer, my lord.
Huh?
Without annexer number 3, my lord. There are some.
You.
I'll provide whatever if they
Whatever is there, is there. Let the matter be listed after 2 weeks. 2 weeks?
It may be
12th August.
There is an interim order.
Interim order, first early will continue.
Deeply. Yeah, please. Well, this matter relates to my lord, the ownership, my lord, the allotment of ownership right, my lord. The petitioner, my lord, the owner of the land, my lord. And respondent 4 to 8, my lord, they are the right. Now, my lord, the respondent number 4 to 8 apply for ownership right, my lord. And the Deputy Commissioner, my lord, served a notice on us. A date was fixed on, my lord, 25/11/21, my lord. We filed our objection, my lord. But the learned Deputy Commissioner, my lord, in the order reflected that we have no objection, my lord. In spite of our written objection, my lord, he said that there is no objection. And my lord, on the very same date, my lord, the Deputy Commissioner, my lord, fixed a compensation, allow them, the respondent to deposit it, and my lord, their name was, my lord, the ownership right was granted. My lord, that could not have been done, my lord, in view of the provisions of section 26 of this Assam Temporarily Settled Tenancy Act, my lord. And rule 9, 10, 11, my lord. May I read, my lord, section 26.
What is your prayer?
My prayer is, my lord, that this grant of ownership right may be, my lord, set aside, and we may.
Where is the impugned order?
Yes, my lord. Page 25, my lord. May I read, my lord?
Yes.
First party of the case, Dhaneshwar Kakoti, is present and file Hazira. The learned advocate for second party is present and file Hazira. At submission of both the parties, there is no objection from the Patadar side. An application has been filed under section 23 of the Assam Temporary Settled Area Tenancy Act for getting ownership right of the land measuring 1 biga 1 kata 8 lakhs in Dag number 199 of Patta number 4 and 7 biga 2 kata 17 lakhs in Dag number 203 of Patta number 4, totaling to 8 biga 4 kata 5 lakhs by Dhaneshwar Kakoti, Jalturam Kakoti, Umesh Kakoti, all are sons of late Jaduram Kakoti, and Parag Jyoti Kakoti, son of late Bhuvan Kakoti, and Srimati Mithurani Kakoti, wife of late Bhuvan Kakoti, Revenue Circle. The circle officer, Kamalpur Revenue Circle, has submitted a report dated 14/11/19, wide number sentences. According to that said report, the land is as mentioned in the document. The applicant, Dhaneshwar Kakoti, sentences are enjoying the possession of the land. Therefore, the applicant are rightly considered to get the ownership right in the said land. The applicants are to deposit 50 times of the land revenue towards the compensation to the landlord by treasury challan. Amount is also calculated, and to submit the original copy of treasury challan before the authority for initiating subsequent process. Now, my lord, this person, first, my lord, our objection was, my lord, not considered, my lord. Secondly, my lord, this portion of the order by which the compensation was calculated, my lord, it could have been on the next statement. Just read my provision of section 26, my lord. Section 26 of, my lord, this may I read, my lord?
Now, what about the pleadings are complete?
My lord, yes.
Pleadings are
It is complete, my lord. They have filed affidavit.
And so far the, my lord, may I submit this?
Huh?
So far the act provides, your lordship may peruse the section 67. Just for a moment. The appeal provision is there. 67, your lordship.
Yes, my lord, we filed the appeal, my lord. We filed the appeal, my lord, then we were told that the record is not traceable. Then, my lord, in the meantime, my lord, then their names were recorded in the
They ought to have
Jamabati.
approached before the revenue board, your lordship, against the impugned order passed by the deputy commissioner. So it's specifically that alternative remedy is there.
My lord,
Deputy Commissioner not
in
passed
spite
any
of that,
order.
my lord, they have approached before this honorable court by filing this writ petition, which is not maintained.
Where is the provision of the time?
90 euros will find it.
This is an order passed by whom?
Deputy Commissioner, your loss.
It goes before the
Additional
revenue board.
Yes, my lord.
No,
Should be before-
additional deputy.
No,
Huh?
wait,
Additional.
All right,
Same.
it goes before the revenue board. Additional deputy commissioner will be deputy commissioner.
Yes, my lord.
But my lord,
Specifically, it is
my
mentioned.
lord, we file an application for my lord, for allowing us a chance to hearing, my lord. That application was filed
Allowing us a chance to hear for where did it file?
to the deputy commissioner, my lord.
Huh.
That is at page 29, my lord.
Page
29,
29.
my lord.
Before passing that order, you were not heard.
No, my lord. Our objection was not considered and were not heard, so we filed this petition, my lord. Then we were told, my lord, that the record is not traceable. And in the meantime, my lord, the names of the respondent 4 to 8, my lord, they corrected in the revenue record. My lord, now they are trying to sell this land, my lord.
It is before the deputy commissioner for the tracing of the record only, but specifically,
No, my lord,
there is a provision that he ought to have approached before the revenue board against the impugn order being passed by the deputy commissioner. Specifically mentioned
My lord,
in
this,
the provision, it is there. Section 67 provides.
my lord, this application was filed on, my lord, 20th December 2019, my lord. My lord, we waited till, my lord, September
Who is for the
21.
deputy commissioner? The record is missing. What steps have you taken?
No, that record is here with me.
Okay. What is at least
That
34?
record, my lord.
34, there is a notice issued by the deputy commissioner.
Yes, notice issued by he was hard, my lord.
No,
That-
page 34 of the paper book here. It shows that there is a notice issued by the additional deputy commissioner.
Yes.
Saying that the records are missing.
This 35. This 34.
34 to record missing.
Replies.
So the record that you are holding is not the same record.
It is not the same record.
Oh.
It is record of the hearing and all. It starts from the hearing of the case.
No, this file KRL.
It is not 5K.
That has to be traced out. Assuming we entertain the petition, we pass some order, it will have to be reflected, it will have to be in connection with this file, KRL.
This
KRL
file with
missing,
the-
then deputy commissioner will have to take some steps.
This record, my lord, starts from the hearing, issuance of notice and hearing of the both the parties.
What does this KRL file contain?
I do not have any idea.
Well, KRL 7, it may be, my lord, this tenancy case by under which, my lord,
That
this
is the
land was
case
allotted.
number.
Tenancy case, it was
Case
earlier.
number
Case number is 7 of
29.
7 of 19.
7 of 19.
7 of 9. That is the case number. But this is the record that has been constituted.
We want to know whether this and this record is a part for is it the same record. Right, but we want to know is if the record is missing, then the deputy commissioner is required to take steps. Find out or maybe file an FIR to find out who's responsible for a record. Being missing from the office.
Maybe. So what was the conflict of the?
Or maybe they will reconstruct the record.
Might have been reconstructed. This might have been the, that doesn't say.
Verify and tell us.
I'll have to verify that.
It's only a question of.
Because this record starts from issuance of notice in the hearing of the parties, that case, my lord.
See, his prayer is that he was not heard.
He was heard.
No, his prayer is he was not heard.
Right.
Now, assuming we fit to the record, for some reason we find that no, he was heard or he was not heard, maybe we'll issue a direction that okay, his matter be reheard again.
He was heard, and in affidavit also we said that he was
But
heard.
he was heard.
Yes.
Whether the presence of this file is the same, the type of hearing.
The contents of this file is not known to me.
Exactly.
My lord, the order dated 25 itself says, my lord, that on the very same date, my lord, the compensations cannot be, my lord, determined. First, that if the commissioner to, my lord, make an order that, yes.
You'll have to find out from the deputy commissioner whether this file that is given to you and this file are they similar file, same file, or is the reconstructed file?
Annex I.
Next.
We want to know what are the contents of this file.
This one is one I have to audit.
What does KRL contain?
See.
See.
Where is the impugned order?
Page 25.
This impugned order is passed in tenancy case number 7, 2019.
Yes.
That is the same, I think, KRL file. That is also 7.
7.
7. That is tenancy case number 7 of 2009.
No, that's what we want. The file that you're holding is also
It relates to KRL tenancy case number 7.
7. But what is KRL file?
Yeah.
Where is the report of the
everything.
circle officer?
All the order sheet, everything.
Is the report of the circle officer available?
Yes. Yes, it is available. It is here.
Then from the file, what transpires that the hearing took place?
Hearing took place, they participated, and thereafter the order was.
Then
My lord, the order also said that, my lord, the advocate for the petition was heard, but it says, my lord, that we did not file any objection. My lord, in the affidavit, the deputy commissioner said that our objection was not tenable, so he rejected the objection. That maybe, my lord, he could have rejected it, but my lord, he has to follow the rules, my lord. Now, may I read, my lord, rule 10? Rule 10 says now the disposal of application for acquisition filed by the tenant, my lord. The deputy commissioner on receipt of an application under Rule 9 shall pose an inquiry to satisfy himself about the eligibility of the applicant to acquire the intermediary right and the ownership right before ordering further proceeding. If the deputy commissioner is satisfied that there is a prima facie case for acquisition under section 23, he shall serve notices in form 6 to all persons mentioned in the application as at applicant's cost and to any other person or persons who, in the opinion of deputy commissioner, are interested in it. Well, this part was done by issuing notice under in form 6, my lord. Normal Rule 11 says, my lord, the deputy commissioner shall hear all objections presented within 1 month of the service of notice under Rule 10 and make a memorandum of evidences, if any, adduced by the parties, and shall, for the purpose of inquiry, have all the powers of civil court. This was not done, my lord. Secondly, my lord, Rule 12, my lord, also violated, my lord. When the deputy commissioner allow the application of a parcel of land by the applicant, he shall record a formal order in the proceeding that to that effect and call upon the applicant to deposit the cost of acquisition as may be estimated under Rule 14. Well, Rule 14 says that prior to determination of compensation, my lord, the landowners have to serve a notice, my lord, about the quantum of compensation. Thereafter, my lord, the compensation can be determined, my lord. In this order, my lord, on the very same date, my lord, the deputy commissioner passed the order. He has also determined the compensation. This process is wrong, my lord.
No, but how are you affected?
I am affected by my lord because the right is no doubt, my lord, entitled to ownership right. But there is a condition, my lord. If they are personally cultivating the land, only in that case, my lord. Otherwise, my lord, if they have subletted to, if the land is under tenant, my lord, then the under tenant is entitled to come, my lord, this ownership right and the intermediary right, my lord. If both are not cultivating, my lord, then it falls back on the landowners, my lord. So my objection is to be considered, my lord, whether they are entitled or not. If they are, whether they are cultivating personally, they are not cultivating.
Your objections are stated to be considered.
No, but my lord, the order says that we
There
did
is
not,
no,
we have no
you
objection.
are the pattada.
Yes, ma'am.
So there is no objection from the pattada side.
No, my lord, but we filed the written objection. We filed the written objection, my lord, on the same date. How we can say,
Is it
my lord,
available there, Mr.
Well, better, my lord, let him decide
Sir,
afresh.
written objection, is it available in the file?
Yes, written objection,
In the affidavit, they have not denied that we have not filed. The deputy commissioner said that well, our objection is not tenable. So he rejected it. But in the order, he said that we did not have any objection. My lord, deputy commissioner may, as per the appropriate proceeding, he can consider the case. On the same day, how he can determine the compensation?
Your affidavit, if you look in filed by the deputy commissioner, page number 36.
My lord.
If you come
page 38, my lord, para 4, he is clearly admitted he filed the affidavit.
para 4 capital A and para 5.
4, para 4.
Capital A. I mean, just
yes, capital.
here.
4 and 4.
So 4A says that they have filed objections, but the grounds are not valid. Whereas the impugned order says there is no objection. If you look into the impugned order,
After hearing, accordingly, after hearing the parties, the deponent passed the order dated 25 to them.
where is the impugned order again? Page 25.
Page 25.
So page 25 says there is no objection from the Pattada side, meaning the petitioner. And para 5, they apparently traced out the records. Okay. It up-
I do not understand this language. There if no objection.
No, the
From the
vulnerability is also there. Page 27.
পাট্টাদার উপর কোনো ধরনের আপত্তি আহত
That is in the order.
নয়।
That is in the order.
Yes, order.
But the affidavit says otherwise.
Everything it says they were heard.
No, affidavit says they had filed written objection. But the grounds were
Tenable.
not considered as valid ground.
No.
There is a difference between the two.
I don't find that objection. Give me some time, I'll go to the reference.
All right. Do we take it up at 2 o'clock or some other date?
Some other things. Next Monday or any other.
Mr. A.C. God, when it comes. Mr. P.J. Talukar, Mr. by Mr. Medi, and Mr. Tibora appearing for
428 euros.
for the paid. Mr. Talukar submit that the reports also are available with him. Right. There was the same. Accordingly, it is the next week.
Friday.
He listed on 26th.
My lord, right? After 30 any day.
After that. Then on 5th of August. 5th of August.
Right.
Cooperative society, my lord. So the petitioner was appointed as a cooperative society's my lord secretary in the year 2000, my lord. One. Prior to that, my lord, private respondent was the my lord cooperative society's my lord secretary. And my lord, there is several allegations against him, and there is a proceeding also that my lord, and he was removed, my lord. Then there are a series of litigation, my lord, going on before this honorable court. Ultimately, my lord, there is a judgment passed by this honorable court. Your lordship kindly see that judgment will your lordship will find at page, my lord, 93, my lord. Page 93, my lord. Writ petition disposed of by a common judgment. Page 93, my lord, your lordship will effective, my lord, that is page 96, my lord. Page 96, my lord. Page 96, your lordship. I heard Mr. M. Hussain, the learned counsel for the petitioner in the 3 cases. The contesting litigants are Abdul Hamid Chaudhary, who is the as a 9th respondent in this represented by the learned counsel, Mr. Ayat Aludar, the registered cooperative society and the other function under the representative Mr. M. Chaudhary, the learned concerning counsel 2020. In these cases, the petitioner and the 9th respondent are fighting for the post of secretary of the East Borderpur Cooperative Society Limited, herein after referred the society. And since the common argument are advanced by the prospective lawyers in this area will be done. The 9th respondent Abdul Hamid Chaudhary joined in Borderpur Cooperative Society a salesman on 11/5/1997, and the 77, and he gained sufficient experience in the managing board and society for appointment him as the secretary with the capacity of the, he served from 23/8/1981 to 4/11/2000. The secretary went on leave on 4/11/2000 and returned back and resumed his duty on 5/3, but it was not allowed to join in the secretary of the order of secretary. In the meantime, that during the leave period of the 9th respondent, the managing board adopted resolution on 28/3/2001, whereby the lead petitioner Kaiser Ahmed was appointed as the secretary, become secretary, salesman come secretary in the Bodarpur society just before the new salesman was appointed for one earlier resolution that changed. So that was the dispute, my lord. Ultimately, this my lord was disposed of with a direction. Your lordship will find, my lord, page 100. What is the direction passed by this honorable court, my lord? Page 100, my lord. Page 100, para 15, my lord. Para 15, page 100, my lord. Page 100, has your lordship got it?
Yes.
From the history of this litigation, it is apparent that the managing board has taken contrary decision at different point of time, and it is obvious that the function of the Bodarpur society is affected by all such confusing resolution. Thereafter, Mr. A. Hussain and the learned counsel for the petitioner, Mr. A. Taludar, as the learned counsel respondent, the 9th respondent jointly submitted that register of the cooperative society should be directed to finally decide on whose should be the secretary of the Bodarpur society. But this submission of the two contesting lawyers is supported by the departmental council in the view of the rule ascertained by register under section 22 decision. A view of the submission, I feel that the cause of justice will be best served in this issue to the secretaries of the Bodarpur society is to decided dispensally by the registered cooperative register in accordance with the above submission made by the learned lawyers. In this issue has been decided after affording hearing up to all the sides. The facilitate the exercise respective representation may be filed by the contesting parties, and the register should give his decision with the speaking order within 3 months from receipt of the intimation of this order. The present arrangement of the secretaryship of the Borderly Society will be abide by the final decision of the register of the cooperative society. It is ordered accordingly. My lord, that was the order passed, my lord. Accordingly, now, my lord, impugn order was passed, which I have challenged before this honorable court, my lord. That is, my lord, your lordship will find page, my lord, 144. In pursuance to that order, that was the passed in 2016, my lord. Now, my lord, on 21/6/2024, my lord, in pursuance to that order, my lord, that this order was passed, my lord. Page 144, my lord. In pursuance to the pair petition of Abdul Hamid Chaudhary, ex-secretary of the East Bodarpur CS Limited, Karimganj, dated 23/2004, seeking charge in secretaryship of the reinduction of C. Abdul Hamid Chaudhary as a secretary of the society for hearing as fixed on 25/2024 in the office chamber of the registered cooperative society, Assam, Khanapara, Guwahati 20, which was later on refixed on 27/5/2024. The hearing held on so was attended by following persons: Brajen Chandra Das, ACRS, C. Heteswar Teron, Kaisur Ahmed, Abdul Qadir, and B. Sinha, advocate for the petitioner. Perusal of the all record, including the High Court order dated WPC number 578/2009, dated 17/6/2016, and also heard both the parties during the hearing. It is observed that the petitioner, Mr. Abdul Hamid Chaudhary, joined in East Bodarpur CS Limited as a salesman on 11/6/2019, 1977, as a secretary on 23/8/1981, served as a secretary till 4/11/2000. Then he went on a leave on 4/11/2000, returned back and resumed his duty on 5/3/2001, but he was not allowed to rejoin in the secretary of East Bodarpur CS Limited by Board of Directors of the Society. On 5/3/2021, Kaiser Ahmed was appointed as secretary of East Bodarpur CS Limited. Later on 25/5/2000, Assam removed his secretaryship again. On 1/2/2000, Abdul Hamid Chaudhary was re-inducted as a secretary. The Honorable Court made an observation that WPC number 578/2009 that from the history of this litigation, it is apparent that the managing body has taken a contrary decision at different point of time. It is obvious that the function of the East Bodarpur Cooperative Society affected by the such confusing resolution. Honorable Court also observed that the decision was taken by the managing body of the East Borderpur Society on 1st February 2003, re-inducts on the 9th respondent Abdul Hamid Chaudhary, and it was observed that to seek approval of the Registered Cooperative Society and it under bylaw of the 27. Subsequently, the Registered Cooperative Society has accorded approval of resolution for his order dated 22/12/2003. Therefore, the exercise of power conferred under Section 49(2) of the Assam Cooperative Society Act, Sri Narayan Kaur IS Registered Cooperative Society, Assam, do hereby uphold the decision of the managing body dated 1/2/23 for induction of the Abdul Hamid Chaudhary, Secretary of this Borderpur Society. My Lord, dear Lordship, kindly see here, my Lord, what is my submission, what is my contention, that was absolutely, my Lord, not taken into consideration. Not a single line, my Lord, my submission and my WS, my Lord, have been considered, my Lord. Your Lordship, kindly see, my Lord, written statement which I have submitted is a 124, my Lord. Details against that, and in fact, my Lord, your Lordship, kindly see, record will prevail everything, my Lord. Your Lordship, kindly see, he was the private respondent, my Lord, his decision, he was upheld. The Assam, last line, very last line of the impugn order, your Lordship, kindly see, to hereby uphold the decision of the managing body dated 1/2/2003. In fact, on that day, my Lord, that resolution has already been cancelled, my Lord, by the subsequent, my Lord, proceeding, my Lord. So that was also, my Lord, placed before this, my Lord, before the ACA Cooperative Society. That was not taken into consideration, my Lord. But this order is, my Lord, totally, my Lord, there is, my Lord, not taken into consideration of my submission, my Lord, my WS, my Lord, at page 124, my Lord. Not a single line of my submission, my Lord, there, my Lord. Page 124, my Lord. That was my written statement, my Lord. In that, my Lord, I clearly stated, my Lord, everything I have stated, my Lord. That order, which was upheld by the Registered Cooperative Society, it was known as, my Lord. So my submission before your Lordship, let them produce the record, my Lord, and my Lord, it is apparent that, my Lord, the submission made by me, my Lord, not a single line was reflected there, my Lord.
Yeah.
Page 124, my Lord. That is my written submission, my Lord.
Okay.
I'll read it, my Lord. With reference to the aforesaid subject, I have the honor to submit here with the following facts for kind perusal of necessary.
Your submission is that these objections were not considered.
Absolutely, my Lord. Your Lordship, kindly, nothing is even reflected, my Lord.
Yes.
In fact, my Lord, there is a FIR filing against him. He was dismissed from the bylaw society, my Lord. He filed a civil suit also, my Lord.
Who appears for this Abdul Hamid?
And moreover, another point, my Lord, nowadays, my Lord, he is more than, my Lord, 67 years of age, my Lord. Nowadays, my Lord, there is a, my Lord, there is a guidelines that all the registered cooperative society has to follow the government guidelines regarding age and others, my Lord. So that way also, he is more than 67 years, my Lord.
No, we want to know, in the beginning of this order, recital of the order, there is a prayer petition by Abdul Hamid Chaudhary.
He is, my Lord.
Abdul Hamid Chaudhary.
Yeah, I was, my Lord. I was the 9th respondent, my Lord. 9 respondent, whatever the
Why did you
judgment.
file that? What was there in the prayer petition? Why do you file for the authority?
No, because the order passed with honorable to dispose of the matter, my Lord.
It was in 2016.
Yeah, 2016. Then it was kept pending, my Lord.
No,
Yes, because
you filed your petition.
no, because I have, but why the so and so is not complying the order of the Honorable High Court? That is the thing, my Lord. Your Lordship may kindly look into the order, my Lord. Then you have the picture.
16 to 24, who was the secretary?
I was the secretary, my Lord.
He is continuing, my Lord, all those days,
From
my Lord.
2001, I am continuing.
From 2000 all days, even though he is removed, even though he is continuing. By virtue of the order passed with Honorable Court, because
So from 2016 to 24, you did not do anything.
no, that is, I was seeking, my Lord, that the order should be passed, my Lord. Since after the death has been considered, my Lord, then why the order of this Honorable Court has not complied with, my Lord? Then only the hearing was taken, my Lord. Before that, no hearing was taken.
Yes, department.
My Lord, just few, my Lord, because the important paragraph has been skipped, my Lord.
Let us first understand.
Yes.
The long gap between 16 and 24. Why? Why the department allowed that to happen? There is a direction by the court in 2016 to dispose of it within 1 month. And you don't dispose it of till 2024. Why?
That instruction, my Lord, I have obtained.
What was, my lord, the, in fact, what had happened? And the registrar decides an issue which is as stale as 2003.
Because what appears, my lord, from the order, impugn order as well as the order of this honorable court, the registrar is, my lord, a authority who approves the resolution, my lord.
My lord.
Per se, my lord, he is not a authority who adjudicates, my lord, the list between the parties. So therefore, in that view of the matter,
No, there is a direction by the court to decide. Direction is very categorical. Page 100, para 16.
correct, my lord, but here it says the submission of the two contesting lawyers, the last part of, my lord, para 15, is
No, you
supported
come
by
to
the
16, you come to 16 straight away.
well,
Second
no,
line.
my lord, we have to read 16, my lord, with 15.
No, you
Because,
read 16.
no, because your lordship will see, my lord, here reference of 27 is mentioned, by law 27. And if we go by 27, my lord, 27 does not permit to adjudicate. So therefore, the registrar, in my humble...
Order is wrong, then you have to take steps to correct it. That was passed in 2016.
Exactly,
You can't
correct.
bypass this order
That is
to say
correct,
that
my
the
lord.
bylaw says something,
Yeah.
the court's order says something else.
That is correct, my lord. What I am submitting, that the, while passing this order, impugn order, my lord, the honorable court's direction has been taken into account. It has
No,
been
it has not been taken into account. Please see.
Para 14, para 14.
Para 16,
my lord.
page 100, read the second line.
100, page 100.
Second line.
The issue may be decided.
Issue may be decided after affording hearing to all sides.
All sides.
Yes.
Then-
No, everybody has been represented.
then
my lord.
continue.
Yes, yes. To facilitate the exercise, respective representations may be filed by the contesting parties, and the registrar should give his decision with a speaking order within 3 months of receipt of intimation of this order. So, in why this has not been done, my lord, in interregnum, my lord, but now, my lord, that in that respect, I have to obtain the instruction. Why so, my lord? Why it been delayed, my
Let him
lord?
obtain instruction.
My lord.
We'll call for the record.
My lord, until then, my lord, it may be stayed, my lord, impugn order has to be stayed.
No, impugned order has been passed on which date?
That is on, my lord, 21/6, my lord.
21/6. So we are almost one.
I am still, my lord, I am holding the, my lord, he is, my lord, pursuing, my lord.
There is an order to my lord, order of magistrate, my lord, to take over the charge, my lord, but he is not
All right.
giving the charge, my lord.
The controller. Heavy control. I also heard Mr.
Yes, 1, 2, 3, 4, my lord.
Representing the Cooperative Department for 1, 2, 3, 4.
My lord.
Mr. B. Sinha for
Question number 6, my lord.
only 6.
Yes.
Heavy. The present petition is by the by where is that order?
144.
One.
Page 144.
First, on 21/6/2024. By the state order, registrar approved, upheld the decision of the managing body dated 1/2003 of the Procedural Cooperative Society, East Procedural Cooperative Society, whereby the private respondent number 7, 6 was reinducted as the secretary of the East Procedural Cooperative Society. So, the earlier round of litigation, had been related with direction which came to be by judgment dated in part of it was W3184 by the state order quoted the sport director as an it is submitted by the General Council that pursuant to the orders passed was not actively considered by the court, like on prayer petitions made by the private respondent, the impute order came passed. Referring to the impute order, that the objections were filed by the petitioner not find any rational or the ground raised by has been discussed. Therefore, the order is contrary to the provisions of the Cooperative Society Act and that apart, its order was passed by the registrar of Cooperative Society without considering the objections made. They call for it to hear. Our order means the other fixed that the notwithstanding the orders of the court passed in 2003, passed on 173, the matter was not considered that there deviate or pursue the matter or ultimately came to file a rare petition which was considered and the order presently carried in court passed. This order reflects that the hearing was held on 27/5/2024 was attended by the person named in the order. There is no infirmity in the order and all objections raised have been considered and the order merely approves the decision taken by the managing court body of the East Church. Like, and therefore, there is the order is given that that the result of the order does not mean that press decision has been private, but extraordinarily affect the decision of the managing body of the East Court. Limited and accordingly. Claim does not call for to hear the state. The registrar merely appeal the decision taken and that decision is it challenged in the present petition? Decision of the
No, man. And
It was already, there is no next, my lord, as record will prevail. There is no such order as on.
my lord, just one submission, my lord, I may be made, my lord, because that this honorable court, while passing the order, judgment order in the 2016, my lord, already made an observation, my lord, and that no any appeal has been filed. That is the para 14, my lord. The observation has been made. That no writ appeal has been filed against that para 14, my lord. So therefore, registrar is bound to, my lord, to accept this one, my lord.
Any approach taken by the East Court of when it comes to the but that 14 by order passed dispose of the directly the register of the like, conduct hearing the contesting party and arrive at a conclusion taking order within 3 months of the date of eviction and till such action is taken. The present arrangement of the secretaryship date of like, the present arrangement of the secretary society provided by the finance of the registrar. From the submissions made that the impugn order passed in deference to the order dated 16, 17, 2021. So what has not been explained before the court is pursuant to the direction by the order dated 17, 2021, why the order is directed to not pass like still 21/6. These instructions that present are not yet passed. According to the court of the matter by returnable 3 weeks. The counsel here for the partner mediator the way furnished steps of respondent number 5 and 7 in 1 week by the question of the interim prayer. The counsels have been heard. It is submitted by the counsel to the petitioner that the petitioner is presently holding charge and has not handed over charge to the private respondent. Is that correct?
Yes, ma'am. Magistrate man has been appointed, but I don't know, today I don't know whether magistrate is.
But I am still continuing.
University taken or not, that I don't know, today I know, till today.
Hearing for the aviator submits that there is an order by the concerned jurisdictional magistrate.
Yes, my lord.
The with charge. But he barely submits that as on date, he does not know whether the charge yet been taken or handed over by
I have not yet handed over.
such circumstance. If the matter be listed again on 21st.
My lord.
21st. In the next date, the parties will maintain status. In respect of the photo, secretary is ordered for it is directed that the relevant reports which contain the particulars of the resolution adopted by the managing director, board of directors of the East Southern Cooperative Society and the hearing conducted by the extra be placed for the court meeting.
Hello, that one.
Resolution of the board of directors of the Cooperative Society presently next state court is approved by the
Date 21 August or July, man.
August 21 July.
Yes, yes. Sunday on that's why, man. Not that Sunday. Obliged.
Oh,
Wait, Your Lordships. Writ petitioners is a bona fide possessor of two lands by say registering his sale deed in way back of 2007, Your Lordship. Thereafter, Your Lordship, on numerous occasions, he has been trying to register his name in the record of right, but he failed, Your Lordship. And thereafter, numerous court cases has been also been initiated by the different parties regarding the said plot of land. Now, thereafter, the repetitioner has approached the deputy commissioner is annexure 4, page 20.
Will issue notice that you say.
Lordship.
It's the other area, except the other part. The dates are.
234.
Had to be listed after the return.
Lordship.
Tendency of the return will not be a part. But
Lordship.
extra copies be furnished.
Lordship.
Within 1 week.
In your manners, these officers, they have lost the record of this case, this appeal. I have spoken to my officer, but they're willing to give him a hearing and pass orders matters on within 15 days. Matter. The conservator, there was an appeal preferred by the petitioner before the conservator. The conservator retired, and the file is also lost.
What is the grievance?
The vehicle of the
Some
petitioner
vehicle was
yes. Under forest regulations matters, it was confiscated.
Who will conduct the hearing?
It's the conservator matters. As an appeal provision in section 49B.
He has filed something.
Yes, he has filed, man. That they have lost, man.
Where is your appeal?
It is the next lordship. Your Honor, okay, your lordship is number 34.
34. Then you consider this application?
Yes, ma'am. Disconnect.
Heard nothing from the party. Standing counsel for it. Then clear that the appeal was filed before the conservator of forest. Has been displayed as the then conservator of forest. For whom the appeal was filed and since surrendered. He, however, failed that the petitioner appears and the appeals before the conservator is here of the past days by regarding the of it thereafter past done it better than not of the scope of the appeal is exposed at 9 page 34. According to the then the conservator of forest and the until of 29 re-hearing explicitly consider the appeal petition filed by the petitioner is included in the 9 page past. Speaking, the petitioner will be given an heard and be ordered and passed petitioner will appear before the conservator within a period of, when will he appear? When will you appear?
Next week. Yes.
For the conservator of forest on 26th
26th of
July
July.
and file a copy of the order along with a copy of the petition. And the so you do one thing to file a certified copy of the order and file a fresh copy of the appeal, which is proposed as Annexure 9 of the Register. The conservator of forest will thereafter here will thereafter here will hear the petition pass the court. The entire process be completed within a period of 30 days from 26th of July.
May this lordship. So the case of the petitioner here is that her only son died in the year 2019 in a vehicular accident, leaving behind the petitioner and her daughter-in-law, her two minor grandchildren. After that, in the month of July of 2019, her daughter-in-law, who here is respondent number 3, filed a MSCT case before Cooperative lordship. And in that matter, the matter was settled in the year 2021, wherein the respondent number 3 was awarded a total sum of rupees 14 lakhs. So, and the respondent number 3 also made the petitioner a claimant in that matter. So now, my prayer is that the petitioner, being a 70 years old lady, she didn't get any amount from that.
Did not appear before the tribunal.
She is one of the claimant, but her daughter-in-law actually appeared.
He did not appear.
She
represented, not
represented. She was represented, but
you were filed before the claims tribunal that you have not received the payment.
No, lordship, payment was received
By whom?
by the daughter-in-law. She filed the case. She filed the case.
You are a claimant.
Was one of the
One of
claimants.
the claimant.
Yes,
The order was passed. The amount has been received by one of the claimants. Why?
By the daughter.
Why have you not raised it before the tribunal? Raised before the tribunal that you have not received the amount. It has been given entirely to the claimant number 1 or 2 or whatever.
Claimant number 1 and 2 is not there as such, but yes.
Where is the order of the tribunal?
Page number 18.
Who is Hemlota?
Hemlata is my daughter-in-law. She filed the case before the MSCT Cooperative. Who here is
Then you have your other remedies, not a writ petition. There are other remedies available to you. Why are you filing a writ petition? Seeking a direction against whom?
To the respondent number 3, lordship.
Who is respondent 3?
He is the daughter-in-law, lordship.
Why should we issue a direction to the daughter? Why? How will a writ lie? How? You withdraw or we dismiss with cost.
Lordship, on the last occasion they appeared, notice was, they,
Maybe they appeared, but we can't issue a direction to the order. Why should we? Monday, it's on Monday. You come back and apprise the court. We learn it. The writ petition is directed against the private respondent claims with the daughter-in-law, and in whose favor the MSCP so-and-so had, and in whose favor the, what is the amount?
14 lakhs.
Amount of 14 lakhs was directed to be released pursuant to an award passed by the Cooperative on 11/9/2021. With the MSc appeal, which is enclosed in the present petition, the daughter-in-law, namely the private respondent, were who is the daughter-in-law?
Respondent number 3, Lordship.
Respondent number 3 has been shown to be the claimant as the natural guardian of the other claimants, including present petition. With the submission of the learned counsel that the present petitioner, being the mother-in-law, also was represented by the claimant pursuant to the award of 14 lakh, and along with interest of 30%. Sorry, 14 lakh. The amount has not been received. Her share of claim has not been received. Therefore, the petitioner is seeking a direction against the private basis is court that no writ can for all issue where against private. The petitioner has remedied available before other forum which open to her pursue either designate the permit petitioner complete her and right then so 24.
The issue in the case is that the petitioner is an agent of a cooperative society. And a retailer license was given to him by the Assistant Director of Food, Civil Supplies and Consumer Affairs. And accordingly, the commodities were allocated to his shop, and he is running his shop more than 100 beneficiaries. In the year 2021, in the year 2022, the system was changed. The distribution was made through online, and accordingly, a portal was opened, that is RCMS, Ration Card Management System. All the agents' license code were inserted in the RCMS, and EPOS machine were given, and they run their shop online. But the petitioner's shop, Lordship, it is still running offline because his license code was not inserted in the RCMS system, in spite of several requests and representations. Can you see the last order, Lordship? They instructed.
They have filed an affidavit.
Yes.
Yes.
You don't want to file a rejoinder.
No, Lordship, prior to that, Lordship, one communication from the additional deputy commissioner made like to place, Lordship.
To whom?
It is from the additional deputy commissioner. It is addressed to the director of food civil supplies.
How have you got it?
Lordship, it was
How did you get an official copy?
His lordship,
It's not marked to you.
perhaps they provide lordship. It is
Correct.
in the lordship,
How it
in the lordship, no lordship, in the affidavit itself, lordship it is reflected, in the affidavit lordship. The letter which I am relying lordship,
Where is it?
yes, lordship, that is, this is letter dated 13/10/2022.
13,
13/10/2022.
page number.
Page number 21, lordship, paragraph 5. This letter, and actually on the basis of that letter and
What is the government notification?
government notification lordship, it is way back that the one ration card, one nation, one ration card is, the lordship, the mission was going on. That is why new agents license code should not be inserted. So the process may not be delayed. That is in the notification it is stated. But 2 years has elapsed lordship in the year 2022 and now 2024. This mission already over, and now his license code should be inserted so that the beneficiaries should get their benefit through online system. Otherwise, they were tagged to the another agent's home, and they are facing so many problems.
They've already filed their affidavit stating that it can be done.
At present. No, I'm fairly certain. Last total lordship, they agreed, and the court lordship made an observation. Can this the last order of
Last order.
Yes.
Somebody was to obtain instruction.
Yes.
Last order. MCTR. Do you have a copy of that order? Okay. Please have a look.
Much. That was communicated, so probably there is no instruction to that effect. This is a temporary phase matter. And letter no. It may take for some time, some more time. Order too much.
Order time.
Bang সময় দেয়,
We are fixing a date.
Well,
29.
29.
29 July?
29 July.
No.
Sorry.
Only 12th of August.
Otherwise, it is a matter of 2022.
Let him get the instructions, otherwise,
Keep the fifth of August.
they have already filed their affidavit. They say that can't be done. You want to file a rejoinder, you file it. You want to file a rejoinder, bringing your grounds as to why these statements are not to be taken into consideration. Then file it.
Lordship, I am with the court, Lordship. No, otherwise the facts and circumstances, Lordship. Otherwise, a person was given license And
filed their affidavit. Have you gone through the affidavit?
Lordship,
They've rejected your contention. You don't want to file a rejoinder.
no, so that's not that the previous order, Lordship, it is
Previous order does not say anything except giving time to the
Lordship.
authority.
Yes, Lordship, they are going to insert,
There is no direction to insert.
but they admit, but
They
how
don't
much time?
admit. They are asking for some time. Don't try to twist
No,
the orders of the court. Why are you trying to do it? Based on 12 August.
Arbitrator, my lord.
Yes.
Agreement is at page 16, clause is at page 18. Arbitrary clause, my lord.
Yes.
And we have issued notice which is at page 21. my lord. Arbitrator may be appointed.
Where is the agreement?
Agreement, my lord, at page 16, clause is at page 18. The arbitration clause. All disputes relating to the agreement will be mutually settled in case of differences. The same will be decided by arbitration, arbitrator in accordance with the provisions of Arbitration Concession Act.
Then where is the notice?
Page 21.
What is it?
Well, Lordship, I don't have any objection. Let the arbitrator be appointed. I am appearing for the respondent number 1.
It's taken, my lord. Arbitrator. It's case mark.
Subcontract agreement.
Yes.
Will subcontract.
My lord.
The agreement signed between the parties is a subcontract which takes all disputes relating to the agreement will be settled. And in case of any differences, the same will be decided by the arbitration. Arbitration and conciliation act. I submitted that because of the role of an application, notice under section 1 issued by petitioner. Dated 2011. The same was it received?
Yes, Lordship.
However, they did not take any step for appointment of the arbiter. Have you filed anything?
No, Your Lordship. It's not a
Lordship, I am for respondent 2.
Necessary or not? Wrongly, they have done it. Not necessary. That's not.
Who is respondent?
Railway. Railway.
All things.
That is not.
You are appearing for the respondent number 1.
Yeah. Yes.
You have not filed any.
No, I have not filed any.
The Mr.
H.
ACT. Council submits that he appears for
Respondent number 1.
respondent number 1. And submits that there is no objection. If the court appoints as for reason beyond their control, they may appoint in terms of the bills they get together. That was section 21. According it is established that by the statutory principle act of 60 as required was not appointed and as the agreement itself contains an arbitration clause. Appoint an arbitrator in cases of differences and disputes. This court will repeat that the petition in
District judge may be appointed, my lord.
establishing their case that direction of the so the hearing accordingly both parties all parties appearing for the parties appearing for the court petitioner and respondent one agree that who is the
Sire, any something, my lord, that list, my lord, contain name, my lord, that district judge,
that
is that.
desired to speak as a judge retire and will be appointed
after timing of that.
Something that pertains to appear 1990 published by the Panchayat reflecting the names of the may be appointed by the arbiter. According to this court, directs that people retire and the arbitrator. So parties will appear for the arbitrator on
My lord, the notice is issued by the arbitrator.
no, but you'll have to prize her.
Yeah.
By this order will have to be communicated.
My lord, after 2 weeks, my lord. Any that.
Here for the arbitrator. Well, 12th of August, and, the arbitrator will formally convey her consent and required under the property act, and if there is no, and if she expresses her consent, then the arbitrator will proceed the arbitration expedition. Arbitration petition for it.
May I present? This was a Panchayat matter regarding the continuation of the vice chairman of the Gram Panchayat without conducting the election. But now the Panchayat bodies are being dissolved, it has become ineffective.
Sir,
Be does, my lord.
he does appearing for
Respondent of 5, 7, 9, 10, 11, 12, and 13.
5, 7, 9, 10, 11, 12.
And 13.
13. Yes, anyone agree? Not the range or my.
Lordship, I'm for the PNR. P. Biswas on behalf of SS.
On which, for which response? Your for
One, two,
PNRD.
PN,
MS to appear for response. Party. And
6 and 8.
then this reported that the guy
One.
Please, Your Lordship. Matter may pass over for the day.
Huh?
Matter may pass over for the day.
for the day.
Lordship, maybe fix it on next week.
Next week.
Next week.
Monday?
Monday it will be little difficult.
It's on 24th. As submitted by both. 24th of July. Yes.
My lord, hearing the respondents are yet to file a reply.
Your Lordship, first and foremost, they have not supplied us any extra copy of the writ petition. Nonetheless, we are going to file it within the week. For I'm appearing on behalf of Mrs. Arbor and respond number 6.
It's on their part, Lordship. We have also not received the copy according to unable to get the instructions.
The council appearing for the respondent submits that they are unable to. The council for the petitioner submits that he will serve the copies within 3 working days. So matter be listed again after 3 weeks, enabling the respondents by their necessary count. To it, the Monica board, the PNRD department, sorry. What department is revenue?
I appear for respond number 6.
Mr. Bora for response 6. Mr. Verma for
State respondent.
Why was it listed for orders by order? The matter is shown as by order. It was mentioned, listed for what purpose? You did not serve copy.
Lordship, I was not aware of that. I apologize for that, Lordship. We'll serve copies immediately. Not reply.
May it please, Your Lordship. Lordship, Mr. S. Bora, standing counsel for GMDA, had prayed for 2 weeks' time to file the affidavit, and Your Lordship had directed that for listing the matter today, the affidavit should have been filed by today.
Mr. Esbora, instruction has been received. So he has some he needs some clarification. More time may be given to file a affidavit. 2 weeks may be given.
It may be given as last chance because the stakes involved are huge. The negative variation has been carried out.
The respondents have not yet filed their affidavit. Whether prayer is made, the prayer for the state, further time is made by the council hearing. And P. Agarwal, that the stakes involved in the matter are substantial and therefore the affidavit is required to be filed in period of as early as possible. The learned council will file their affidavit within a period of 2 weeks from today. Matter be listed again on 19th.
Lordship, it will be a month again.
12.
Obliged, Lordship.
Yeah.
Respondent had want to file affidavit.
Not file affidavit.
My lord, I have not filed till today, my lord. My lord, only problem is that the copy that has been served upon us, my lord, is not a clear copy, my lord.
There are fresh copies. There are council for the respondent submit the legible copies of the petition.
It may
So the petitioner is directed to furnish the copies within a period of
It may be listed on next week, my lord.
1 week from today.
My lord.
Better be listed thereafter. Serve
If
copies
you look-
within 1 week.
Lordship, I'll submit,
You do it within 1 minute.
Obliged.
My lord, in this matter, for respondent number 6, 7, and 8, it has been shown that the service has been completed. However, my lord, 6, 7, and 8, they have shown the addresses, they are members of a society, my lord. But they have shown it as under the care of the registrar of cooperative society. My lord, we have, registry had sent it to the registrar of cooperative societies, but they could not trace out the persons because they are not employees of the registrar of cooperative societies as well. The petitioners.
You take fresh steps on the respondent.
6, 7, and 8.
That is corrected. then.
As per the last order, Lordship, it has shown that the service upon the respondent number 6, 7, and 8 has been completed,
No,
Lordship.
completed because they were served to the registrar.
My lord.
Yes, Lord.
The registrar is not able to send it further because
they are members of private society.
Who are the petitioners?
They are also members of a society, my lord, Ubustar Cooperative Society.
They are the
Why-
shareholders.
Why don't you serve it through the secretary of the cooperative society?
Lordship, I will verify the matter. And Lordship, if necessary, then fresh step will be taken on it.
Because page number 10, it may be in my lord. In the first
Learned,
title.
Counsel for the respondent submits that the address of the private respondent 678 is going to be care of registrar of cooperative society. And accordingly, that taken to be served the office of the registrar of cooperative. However, the same could not be forwarded to the respondent 6, 7, and 8 as their proper addresses are not registered. Submit that fresh steps directly taken by the respondent by the respondent. Thereafter, the counsel for the petitioner submits that we would like to we would like to take fresh steps on respondent 6, 7, and 8 at the correct level. Alternative petitioners are given liberty. You can take custody if you want.
Yes, Lordship.
Given directed to take custody service from the registry office. Matter be listed after 4 weeks. Meanwhile, the state respondent, departmental authority filed their complaint.
Obliged.
Obliged.
Okay, respondent number 2 was supposed to file the affidavit. Here we have challenged one, my lord, impugn, my lord, penalty and demand notice, my lord, issued to the Assam Cricket Association by the service tax authority. Reason is, my lord, is barred by delay, my lord.
Now, who do you represent?
My lord, here the ACA, my lord.
ACA.
My lord.
Who represents the respondent?
SC KL is because they are. Today, my lord, the names are not reflected, my lord. Probably they have missed.
So, are the council's names not registered in that email and what?
Actually, my lord, in the filing memo, my lord, you have to mention it by hand that so and so.
Or even after that, you can get it registered. Submit it that these are the numbers. Your updates will come.
Automatically it should come, my lord. But here, my lord, it has been shown as central government advocate. So probably for that reason.
Where is Mr. Kial? So what is to be done?
They are supposed to file the affidavit. We are under interim protection.
Heard Mr. P. Goy when it comes to submitted that the respondent central government service tax authority but I the report it represents yes people by the right interim order park circuit.
In connection with this case, Lordship, an application for impeachment has been filed by my senior counsel, Lordship. So far the application is concerned, I have no objection, Lordship, they may be implemented.
deduct any listed by the A Kaluta. I treatment, I treatment of the applicants. How many applicants?
Two.
The council appearing for the opposite party submit that there is no objection. I allow that. That view of the matter. I allow the applicants if the Ojoy Kumar Das and Vijay are implicated as party responsible for 11 and 12. 11 and 12.
No, 7 and 8. 6 respondents are there.
7 and 8. 7. In the PPT number. The petitioner will file amended proposal for the registry. And within 1 week, I voting is allowed.
So far, petition is concerned, they are supposed to obtain an instruction regarding the.
You'll have to now get them immediate, and we'll have to issue notice. So you file the amended post title and listed after that. Petition immediately after 2 weeks.
1 week.
1 week. Upon filing the amended post title is directed by the right in view of the order pass of the high right.
My lord, here they were supposed to file affidavit, my lord. Respondent NC Hills, my lord.
But we have received our instructions.
C. Tharma, Learned Study Council, and the like to file affidavit. People were it will be listed after weeks.
Earlier interim.
Interim order is there.
Yes, protection was there, 5-6. Since it's a, my land, my lord, I'm in possession of that. Last line.
Interim order passed on 5/6/2024 will continue until further notice.
Obliged.
On the last occasion, Lordship has directed to obtain instruction regarding the report, Lordship, that has been already submitted to the district officer, Dibrugarh, Lordship. Lordship may pay.
Do you have a copy to be served?
Yes, Lordship, we have got it.
Now, the report is there now.
Lordship, the matter perhaps may be disposed. That is the admitted or agreed position. They have got the land surveyed by the Assam government land survey. Otherwise, initially, Lordship, what was the report of the joint survey commissions? So it was almost, not almost, 2 bigha, 5.5 lessons. They actually were using for the purpose of, but the land was not acquired. Now, at least to this extent, there is a proposal from the government. Lordship, direct purchase, under the direct purchase policy, government advised Lordship, let me Lordship. If Lordship under that letter, if the party is not willing to accept this, then the land is to be acquired by acquisition process. Now, Lordship, so far that
Now in view of this report, what further order is necessary?
in view of this report, Lordship, we have got only 1 bigha, 3 katha, 16, 16, three katha, 16 lessons of land they have found to be utilized by them. So little bit lesser, 3 katha, 16 lesser, yes, Lordship. So about 1.5 kathas less than the original.
Where is the land here in this report?
My land is at that number 8 and 9, Lordship.
In Japoragaon?
Japoragaon, yes, Lordship.
And what is your total area of land?
Total 8 and 9 comes to Lordship 1 bigha, 3 katha, 16 lesser.
No, that is the area used by them.
Yes, Lordship, that is admitted. This is the survey of the land at their instance, Lordship. So if this is the correct position, then Lordship, we don't have any objection. If it is,
We are asking you. In the land which was under your occupation,
yes,
the entire land is used by them or a part of it?
no, whatever is found, this is the used land, Lordship.
Used land.
Used
So
land.
what is the land under your occupation?
In my occupation, it will be more than 3 bighas, Lordship.
Okay. Then whatever so this report was in respect of a land under so and so circle for acquisition of land.
Yes, Lordship.
So what is the land has not been, that has been utilized but not acquired.
Not acquired. It
Not
was
acquired.
acquisition at that time, but not acquired.
Then-
That acquisition part was left out.
Then you'll have to still
Lordship.
acquire.
But here is a dispute. According to them, the Water Resource Department, the amount has already been paid.
Already been paid in the year 55 only. This dike has been constructed in the year 55. And the petitioner claim is that their father has purchased the land in the year 74.
Do you have the particulars of payment made?
Yes, we have. We have.
In our Lordship affidavit in reply, we have stated it.
You have received?
No, we have not received. That is denied.
Paid where?
Lordship,
You have paid to whom?
to the land affected landowners at that moment of time.
Landowners or the deputy commissioner?
No, to the deputy commissioners, and accordingly deputy commissioners have distributed the land to the means compensation.
Your record will only reveal the amount.
Yes.
deposited in the
Definitely. I may produce the records, Lordship, regarding the payment of compensation in regards to that particular dike, Lordship.
Disbursement landowner.
Yes.
Is not made by your department, made by the revenue department.
Yes, Lordship. It is being paid by the deputy commissioner of the concerned district,
Right.
Lordship.
So how do you have records of that?
No, we have disbursed the amount to the deputy commissioner.
That information, in your affidavit, what have you stated?
Affidavit in reply, Lordship, may kindly turn. No, this one. Yes.
They have not stated anything regarding that.
I believe. Most probably that reply copy has not been served upon us. Reply affidavit. Revenue আর water resource সব দিচ্ছে। তোমালোকেও দিচ্ছে না?
At 198 page of the reply affidavit, para 6. এখানে continuation.
মই পোৱা নাই স্যাৰ। হ'ব মই লৈছো দিয়ক আপোনাৰ ওপৰত।
Leading দিয়া third para 6, third subpara, page 198.
No, you have denied. Then you bring it on record. In terms of the earlier order part, report. Report, not dated 21/6/2024. The survey report dated 21/6/2024. Respect of DTP, Dike, branch, -1. As per the report, copy of the same submit that under the village of Poragaon, tag numbers 8 and 9, comprising of an area of 1 bigger 3 quotas, 16 letters, have been shown to be used for construction of the construction slash repair of the dike. So, council admitted that the area of 1 quota 3 letters belonging to the reputation has been utilized for construction of the dike, but same was never acquired as per the procedure prescribed under law, and no compensation to that effect was ever paid. Whereas the submissions of the petitioners are disputed by the council. PhD
Water resource.
Submits that they have all records showing the payment of compensation at the time when the
Dike
dike was acquired in the year
1955.
1955. He, however, submits that this report, the total report by way of an affidavit. He brings to time. General counsel submits that the funds were already dispersed. That owners at the relevant point in time. So, with the affidavit, we filed in a the deputy commissioner. All right, let the affidavit come first.
Lordship. May I
Lordship,
Let us see.
may I submit one point, Lordship? Lordship, what happens, annexer 3 to the original at page 32, read petition, Lordship. Here there is an Assam Gazette copy dated 27 September, December 2013. Then, Lordship, what they have paid was for DUG number 3, 4, and 6. Nowhere they have been so far denying that the DUG number 18, 8 and 9 were being utilized. That is the reason why they were insisting, in spite of joint survey earlier at the level of the deputy commissioner. Now, Lordship,
Let the affidavit come, things will-
yes, Lordship, that is there, that is there.
copy of the report submitted by the accountant for the revenue is kept. Is after 2 weeks.
After 2 weeks.
Can it be 3 weeks, Lordship?
It is already getting delayed. You must make an attempt to.
Yes, I will. That's why, Lordship.
Always 3 weeks.
Lordship, deeply obliged.
Obliged, Lordship.
Wait, please, your Lordship. Lordship, this is Gracia Mehta, my lord, petitioner's husband died due to accident on 18/1/2017, my lord. My lord, have some orders, my lord, to verify.
Do you admit or what? Affidavit?
Affidavit admitted, my lord. That is affidavit of respondent number 3, page 27, my lord. Final report submitted.
Where is that?
Second para, my lord. After completion of investigation of the case, submitted into final report by the
In next para, my lord, the deputy commissioner has stated that next of kin certificate has not been submitted, my lord, due to which it cannot be forwarded to the revenue department, my lord. Para 27, last 3 lines, my lord.
You submit the next.
Submit, my lord. I will submit.
Third letter comes by on the of the ex gratia which the title which claim with the title in the fact that her husband he died in what?
Died in due to road accident.
Died in a road accident. Stop killer rapid patient 15 November 2015 where the ex gratia announced by the government of Assam cases of persons killed in road accident is the tune of rupees 2 lakhs. So he has running from legal courts. Our claims have not been addressed. They agree with the stated that the investigation is concluded and the final report being FR 19 slash 2017 dated 27 2017 is case number 39 of 2017 17 so the state affidavit there is also a statement in the affidavit that the petitioner did not submit the text of the affidavit. It is considered an essential document. Relying the affidavit unless the next of the certificate punished the further process of sanctioning of a petition thereafter the Carla that it file the next of the PC.
Yes.
Within
Within 15 days.
within 2 weeks. Thereafter, and according to the of that, the respondent authority process the prayer program of which of the 279 AIC was instituted terms of the affidavit filed by the respondent three. The final report being final report was submitted to the petitioner having submitted before the petition next of the certificate within a period of time that if the court find that prima facie it appeared that the petitioner would be entitled for grant of ex gratia in terms of the litigation data. Therefore, they so directors responded number
Three.
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 Three is the DC or it is
He is the
Deputy Commissioner.
Deputy Commissioner.
Deputy Commissioner. One and six.
The petition is disposed of, permitting the petitioner to furnish a copy of the next of kin certificate for the respondent number three within a period of 2 weeks from next of kin. Upon such submission of the next of kin certificate, the DC Morigaon will thereafter make necessary inquiries into the matter. If it is found that the petitioner's late husband, that the petitioner indeed entitled to be granted an ex gratia of tax in terms of modification 15 November 2015 as per scale number 3, same modification. But then a proposal to that effect will be put up by the DC respondent number 3 before the respondent number 1 in the disaster revenue and disaster. So the any proposal that is placed in the respondent number 1 by the DC pursuant to such inquiry made shall be disposed of by the respondent number 1 in a further period of
3 months.
3 months.
And
Why?
budget also we apply.
Within a period of 90 days.
2
From the
months.
date,
2 months.
90 days from the date of receipt of such a proposal from the DC Oregon. It is made clear that the proposal be processed by the DC will only comment upon purchasing of the next of the certificate by that with the above observation that disposed of order in the next step. What about
46 is
46?
here, my lord, petitioner's father died.
Here is my lord, Deputy Commissioner has already accorded sanction and sent it to the Revenue Department. My lord.
That's
This is the instruction.
close to the affidavit.
No, my lord, that instruction yesterday I have received.
There is
Affidavit is not filed. Serial number 6, my lord.
Six.
Next week.
This sanction order is from DC.
Yes. Then it goes to the Revenue Department for payment, my lord. After approval, then we will release that.
Heard counsel regarding the petitioner because it spoke against the what son of late so and so who expired in the sustained in motor accident that took place on 4/1. Stop the petitioner is for the court claiming the benefit of ex gratia granted to the petitioner in terms of 15 November 2014. Stop. The response to the final affidavit wherein it is stated that it is considered 2020 under section 79/38/IPC. After completion of necessary investigation, charge sheet ID, charge sheet number 4/2020, dated 29/1/2020, submitted. So today when the matter is called up, court sanction order to be issued by the deputy Riga, ID order dated 1960, whereby sanction of as many as sanction of ex gratia for as many as 9% are reflected. Serial number 6 reflects the sanction in respect of the father of the late, father of the present submitted that sanction order has already been forwarded into the department. Consider the state, the direction, expeditious direction responded one. Consider the sanction order and make necessary payment the petition in terms of the sanction order in a period of 60 days from the date of receipt of the service. Thank you.
Keep reply.
Public.
Lordship, in this case, we need some time to obtain our instructions.
Yes, Mr. Brahman.
My lord.
Any objection?
No objection.
Mr.
M. Bhuya, Lordship.
M. Bhuyan, Learned Counsel, appearing for the
Respondent number 5, Lordship.
respondent 5.
We have filed our affidavit, my lord, 2 and 3.
Time. Appearing for the health department. For further time. MSM for counsel appearing for deputy commissioner.
Yes, my lord, 2 and 3. Affidavit has already been filed, my lord.
Submit that the affidavit is for 5. The PR also for
1 minute.
1. Anything to be filed?
No, not required.
Appears for response. View of the prayer made by the and not obtained by the council. But after how much time you require?
2 weeks time.
2 weeks. Still after 2 weeks. On a date to be fixed by the registry?
Yeah. My lord, earlier, this interim order.
Interim order passed earlier will continue. It is directed only.
Or
Continued until further order.
by.
Much obliged.
Obliged.
May I please? This is Lordship may allow further 1 week time to file our application.
Mr. A. Chetri, Learned.
I have a small problem. Your losses will look into the earlier patient.
Earlier
Your
patient-
losses give a ample opportunity to respond of 4, 5, and 6 to file the PDB. Oh, there is a certain information I sought from the Joint Development Authority. It denied. Then I went to the appellate authority. Appellate authority passed an order. In spite of direction by the appellate authority, he has not complied it. Well, I have no objection if a affidavit opposition has been filed by informing the all the information I sought for. But a fixed date next week, telling which the JDA chairman may be personally appear for this follow.
Oh. Yes, next week.
What information do you want?
Well, first and next time, well, yes, well, yes, 20, well, 21, well.
Why are you asking for cash book? Why are you asking for the cash?
Sorry, my
Are you
Facebook
employed
case.
there? Are you employed under the?
No, right to information, under that act, I approached this ADA. Then I went to appellate authority. Subsequently, by order dated, and a base, annexa J, K, J, page 41, the appellate authority directed the JDA to provide the information. In spite of this direction, that is order dated 19/5/2023, the JDA authority till date failed to provide those information. So that is why earlier the says given the ample opportunity to the rational point.
Yes, so this will need some time to file our affidavit because on
And that authority, most only as per my knowledge, he is going to be retired by shortly. That is why I deny, they are dragging the matter. My responsible
I'm
service
not
is
dragging
also
notice.
let them file the affidavit, giving the providing the information. Next week, telling us they
By 1 week.
Yes.
1 week.
Yes, yes. 1 week.
associate date may be fixed on that.
That will be
Telling us he shall personally appear before the court.
Appearing for respondent by use this prayer affidavit. Decca, you are appearing.
Respond number 4, Lord.
1 to 3, I am appearing, my lord. 2 has already been filed affidavit. R2 has filed.
Considering then it is already an order passed by the
Respond number 4.
Resolution number 4, dated 19/5/41 page.
by the Assam Information Division by the order dated 95/2023 directing the PIO, the Office of Contract Development Authority, furnish the detail of the that the respondent is authorized for and by the by the dignity and has free for a file their activity to advise the party. Directed that even though failure of the respondent
4 and
number
4 and 5.
5 and 6.
by their affidavit would be passed.
Okay.
Let the matter be listed again 29 July. Yes.
Lordship, that is still pending, Lordship. The final decision is not yet taken. It is still under consideration, Lordship. That is what is my instruction today morning.
Decided on merit, my lord, that they are not taking any decision on application.
To take the decision.
In fact, this a board was constituted for this deciding whether the no objection should be granted.
I have applied, my lord.
Yes, pleadings complete.
I have applied before the GMD. GMD has forwarded my application.
That is pending before the defense
It
authorities.
is submitted that the pleadings by the parties are complete. Have to be listed for admission hearing. Tell us when you want.
Lordship, in the month of August, if in between that, if any decision is taken, I will inform your lord, intimate that.
6th of August.
6th of July.
6th of August. Yes.
Well, the person to lordship's last order, they have given the material on seal cover. খুলি দিও। প্রথমটো উপর
Smaller one.
Yes, this one. It is in seal cover. No?
What is your name?
ভবকৃষ্ণ বর্মন।
They say that you have several cases against you. There's several cases registered against you.
We have replied to the by our affidavit that my lord, some cases where those cases were against us has been if submitted a FIR against all those my lord.
What is the parameter to decide whether there is a threat, how to assess by the court?
My lord, the court cannot assess. The only thing is the review committee has decided.
They have decided that there is no threat perception. There are, they have.
And my lord, can I make a small prayer? This whatever has come, my lord, by an affidavit, I can.
If they can do it, they would have brought it by way of an affidavit. They don't want to do it. Whatever it is.
Not that document, my lord, at least by an affidavit, they will say there is no threat for
That one can, but we have no.
that they will not give.
But that is that answer. How do you know if you know that? You not even ask.
That only thing, my lord, your lordship may give us some time. We will have some instructions from our client, my lord. Then your lordship will close.
There is a parameter, there are precedent, say.
Huh?
But
Your lordship may pass that type of order. My instruction goes that review committee will look after all those allegations that I have brought. Then, my lord, on that basis, they will decide. If they reject it, that is thereafter.
they have rejected, isn't it?
It is rejected in the month of yes, my lord.
They have rejected.
In the last meeting, my lord.
Review committee has already rejected.
My lord, if then, my lord, I will ask the instructions, my lord, that they have rejected my pair. So the court has no parameter to decide on this.
We cannot assess those this matter with the director that in case you face further threat, the authority.
My lord, my lord, my lord, that's
Yes, yes.
That much.
These are dynamic things, my lord.
Your lordship may pass that and dispose of.
Lordship.
This court by the earlier order, placed below the court by the senior government, seal up. Sorry, finance of the state security review committee placed before the court seal up by the held that the SSRC state security in its finance held that there was a threat perception criteria which calls for security cover. So, let's say court directed this court permitted this conduct. It clears the material which were clearly arts, the basis of which the elders arts came to the conclusion that they have committed there are bail. The other city governor is read assessment submitted by the commissioner of police department. On the basis of the report, see that on the basis of the information collected, it is reflected that since that that has given a report that that the growth of the that submits that the threat perception, the dynamic concept of the threats where a situation was perceived by or viewed by the threat perception of an at may not be as a may not be as a basis for the threat perception made by the that direct concept that complaint or situation may be made, which may be expressed, apprehension expressed, complaint or apprehension expressed respect of his personal safety and security before the respondent or particularly and thereafter may give express consideration that threat or apprehension that it the person be above the police station SP, jurisdictional SP,
Jurisdiction SP.
jurisdictional
Here,
in the UN, the particular cases, fresh threat or fresh threat or apprehension in by the people. It is that authority. We take a breath after breath that may be fixed by thereafter. But at the same time, but the respondent did not rely on retrospective reports. It is but such order and the equal hope that make such threats apprehensible. Such threat has been used by
Obliged.
In
terms of the in terms of the above direction and for the other we pass similar orders. Dispose of reporters depending that
in respect of Guwahati, it may not be the SP, Commissioner of Police will be there.
Commissioner of Police slash
Yes,
jurisdictional SP.
Lodge.
As the case.
Mine one is 51 and 53.
51 and 53.
Same petitioner.
Roy Chaudhary. Same petitioner.
Same petitioner,
Same
because my lord, one was on apprehension, another, they have executed they have withdrawn their PSO. One I approached this court on apprehension, another after they have withdrawn the PSO, then I. So 51 and
The
50.
first one has become
Redundant, infructuous. First 51 is not required. This order may come on
Why
53.
did you, so 51, you say, right, 51, 51, right, 51, and petitioner had approached this court on orders that were passed by the SSRC. What is that?
State Security Review Committee.
SSRC recommending withdrawal of the PSO. No, the PSO was thereafter withdrawn and consequently item was item number. Accordingly, right, petition 2088 of 2024 has become 52 and 50. Correct? Yes.
I'll take that.
Yes, yes, of course. You
Lodge.
take back
I'll-
put it back in field cover. Whatever it
True, Manoj.